can all be seated. All right, folks, we're back on the record in FECR 153477. Jurors, I will now be reading the court's jury instructions. You've each been provided a copy of the instructions to follow along if you wish. However, you're not required to follow along. You'll have the written instructions with you in the jury room when you retire to deliberate. So those are just being provided to you as a courtesy if you wish. Members of the jury, the state of Iowa in this case accuses the defendant, McKinley Louisma, of the crimes of murder in the first degree in violation of Iowa Code Section 707.1 and 707.21a, kidnapping in the first degree in violation of Iowa Code Section 710.1 and 710.2, and conspiracy to commit a forcible felony in violation of Iowa Code Section 706.1b and 706.31. To each of these charges, the defendant has entered a plea of not guilty. Upon the issues thus made, you are instructed as follows. Instruction number 1. The trial information charges the defendant, McKinley Louisma, with the crimes of murder in the first degree, kidnapping in the first degree, and conspiracy to commit a forcible felony. Murder in the first degree includes the lesser included offenses of murder in the second degree, involuntary manslaughter by recklessness, and involuntary manslaughter by conduct. Kidnapping in the first degree includes the lesser included offenses of kidnapping in the third degree and false imprisonment. Instruction number 2. The trial information is the document that formally charges the defendant with a crime. It is merely the method by which the defendant is brought into court for trial. It is not evidence. Instruction number 3. McKinley Louisma has entered pleas of not guilty. The plea of not guilty is a complete denial of the charge and places the burden on the state to prove guilt beyond a reasonable doubt. Whenever I instruct you, the state must prove something. It must be by evidence beyond a reasonable doubt. If the state does not prove the defendant guilty beyond a reasonable doubt, your verdict must be not guilty. Instruction number 4. McKinley Louisma is presumed innocent and not guilty. This presumption of innocence requires you to put aside all suspicion which might arise from the arrest, charge, or the present situation of the defendant. The presumption of innocence remains with the defendant throughout the trial unless the evidence establishes guilt beyond a reasonable doubt. Instruction number 5. You must determine whether McKinley Louisma is guilty or not guilty from the evidence and the law in these instructions. My duty is to tell you what the law is. Your duty is to accept and apply this law and to decide all fact questions. You must consider all of the instructions together. No one instruction includes all of the applicable law. As you consider the evidence, do not be influenced by any personal sympathy, bias, prejudices, or emotions. It is common to have hidden or implicit thoughts that help us form our opinions. You are making very important decisions in this case. You must evaluate the evidence carefully. You must avoid decisions based on things such as generalizations, gut feelings, prejudices, fears, sympathies, stereotypes, or inward or outward biases. The law demands that you return a just verdict based solely on the evidence, your reason, and common sense, and these instructions. As jurors, your sole duty is to find the truth and do justice. Instruction number 6. The duty of the jury is to determine if the defendant is guilty or not guilty. In the event of a guilty verdict, you have nothing to do with punishment. Instruction number 7. Nothing I have said or done during this trial was intended to give any opinion as to the facts, proof, or what your verdict should be. Instruction number 8. You must base your verdict only upon the evidence and these instructions. Evidence is 1. Testimony in person or by deposition. 2. Exhibits received by the court. You may examine the exhibits closely, but be careful not to alter or destroy them. 3. Stipulations, which are agreements between the attorneys. Facts may be proved by direct evidence, circumstantial evidence, or a combination of both. The following are not evidence. 1. Statements, arguments, questions, and comments by the lawyers. 2. Objections and rulings on objections. 3. Testimony I told you to disregard. 4, anything you saw or heard about the case outside the courtroom. Instruction number 9. The burden is on the state to prove McKinley Louisma guilty beyond a reasonable doubt. A reasonable doubt is one that fairly and naturally arises from the evidence in the case or from the lack or failure of evidence produced by the state. If, after a full and fair consideration of all the evidence, you are firmly convinced of the defendant's guilt, then you have no reasonable doubt and you should find the defendant guilty. But if, after a full and fair consideration of all the evidence in the case, or from the lack or failure of evidence produced by the state, you are not firmly convinced of the defendant's guilt, then you have a reasonable doubt and you should find the defendant not guilty. Instruction number 10. McKinley Louisma has been charged with 3 counts. This is just a method for bringing each of the charges to trial. If you find him guilty or not guilty on any one of the 3 counts, you are not to conclude he is guilty or not guilty on the others. You must determine whether he is guilty or not guilty separately on each count. If there is a reasonable doubt to any crime, Louisma shall only be convicted of the crime which there is no reasonable doubt. If there is a reasonable doubt as to the degree of the crime, he shall only be convicted of the degree for which there is no reasonable doubt. Instruction number 11. Where 2 or more alternative theories are presented, or where 2 or more facts would produce the same result, the law does not require each juror to agree as to which theory or fact leads to his or her verdict. It is the verdict itself which must be unanimous, not the theory or facts upon which it is based. Instruction number 12. In considering the evidence, you may make deductions and reach conclusions which reason and common sense lead you to make. You should not be concerned about whether the evidence is direct or circumstantial. Direct evidence is the testimony of one who claims actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is proof of a chain of facts and circumstances indicating that the defendant is either guilty or not guilty. The law makes no distinctions between the weight you may give to either direct or circumstantial evidence. Instruction number 13. Decide the facts from the evidence. Consider the evidence using your observations, common sense, and experience. Try to reconcile any conflicts in the evidence, but if you cannot, accept the evidence you find more believable. In determining the facts, you may have to decide what testimony you believe. You may believe all, part, or none of any witness's testimony. Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. There are many factors which you may consider in deciding what testimony to believe. For example, 1, whether the testimony is reasonable and consistent with other evidence you believe. 2, whether a witness has made inconsistent statements. 3, the witness's appearance, conduct, age, intelligence, memory, and knowledge of the facts. 4, the witness's interest in the trial, their motive, candor, bias, and prejudice. Instruction number 14. To commit a crime, a person must intend to do an act which is against the law. While it is not necessary that a person knows the act is against the law, it is necessary that the person was aware he was doing the act and they did it voluntarily, not by mistake or accident. You may but are not required to conclude a person intends the natural results of their acts. Instruction number 15. Specific intent means not only being aware of doing an act and doing it voluntarily, but in addition, doing it with a specific purpose in mind. Because determining McKinley Louisma's specific intent requires you to decide what he was thinking when an act was done, it is seldom capable of direct proof. Therefore, you should consider the facts and circumstances surrounding the act to determine McKinley Louisma's specific intent. You may but are not required to conclude a person intends the natural results of their acts. Instruction number 16. All persons involved in the commission of a crime, whether they directly commit the crime or knowingly aid and abet its commission, shall be treated in the same way. As used in the instructions related to counts 1 and 2, aid and abet means to knowingly approve and agree to the commission of a crime, either by active participation in it or by knowingly advising or encouraging the act in some way before or when it is committed. Conduct following the crime may be considered only as it may tend to prove the defendant's earlier participation. Mere nearness to or presence at the scene of the crime without more evidence is not aiding and abetting. Likewise, mere knowledge of the crime is not enough to prove aiding and abetting. The guilt of a person who knowingly aids and abets the commission of a crime must be determined only on the facts which show the part he has in it and does not depend upon the degree of another person's guilt. If you find the state has proved the defendant directly committed the crime or knowingly aided and abetted the other persons in the commission of the crime, then the defendant is guilty of the crime charged. The crimes charged in counts 1 and 2, as well as lesser included offenses for counts 1 and 2, require a specific intent. Therefore, before you can find the defendant aided and abetted the commission of the crime, the state must prove the defendant either has such specific intent or aided and abetted with the knowledge the others who directly committed the crime had such specific intent. If the defendant did not have the specific intent or knowledge the others had the specific intent, he is not guilty. Instruction number 17. For the defendant to know or have knowledge of something means the state must prove the defendant or the person he aided and abetted had a conscious awareness of the act being done. Instruction number 18. Evidence has been offered to show that McKinley Louisma made a statement at an earlier time and place. If you find any of the statements were made, then you may consider them as part of the evidence. Statements and questions by law enforcement officers during interviews with Louisma are not evidence. Those statements and questions by law enforcement may only be considered to place the defendant's answers into context. However, only his answers and responses to those questions and statements are evidence. Instruction number 19. You have heard evidence claiming witnesses made statements before this trial while not under oath, which were inconsistent with what the witness said in this trial. Because the witness did not make the earlier statement under oath, you may use them only to help you decide if you believe the witness. Decide if the earlier statements were made and whether they were inconsistent with testimony given at trial. You may disregard all or any part of the testimony if you find the statements were made and they were inconsistent with the testimony given at trial, but you are not required to do so. Do not disregard the testimony if other evidence you believe supports it or if you believe it for any other reason. Instruction 20. You have heard evidence claiming certain witnesses made statements before this trial while under oath, which were inconsistent with what they said in this trial. If you find these statements were made and were inconsistent, then you may consider them as part of the evidence, just as if they had been made at this trial. You may also use these statements to help you decide if you believe the witness. You may disregard all or any part of the testimony if you find the statements were made and were inconsistent with the testimony given at trial, but you are not required to do so. Do not disregard the trial testimony if other evidence you believe supports it or you believe it for any other reason. Instruction number 21. You have heard testimony from persons described as experts. Persons who have become experts in a field because of their education and experience may give their opinions on matters in that field and the reasons for their opinion. Consider expert testimony just like any other testimony. You may accept it or reject it. You may give it as much weight as you think it deserves, considering the witness's education and experience, the reasons given for the opinion, and all the other evidence in the case. Instruction number 22. In this case, McKinley Louisma has decided not to testify. He is not required to testify, and no inference of guilt shall be drawn from that fact. The burden of proof remains upon the state to prove the guilt of McKinley Louisma. Instruction number 23, count 1. The state must prove all of the following elements of murder in the first degree. 1. On or about February 17-18, 2024, McKinley Louisma, or the person he aided and abetted, strangled Melody Hoffman. 2. Melody Hoffman died as a result of being strangled. 3. McKinley Louisma, or the person he aided and abetted, acted with malice aforethought. 4. McKinley Louisma, or the person he aided and abetted, acted willfully, deliberately, premeditatedly, and with a specific intent to kill Melody Hoffman. Or, the state must prove all of the following elements of murder in the first degree. 1. On or about February 17-18, 2024, McKinley Louisma, or the person he aided and abetted, strangled Melody Hoffman. 2. Melody Hoffman died as a result of being strangled. 3. McKinley Louisma, or the person he aided and abetted, acted with malice aforethought. 4. McKinley Louisma, or the person he aided and abetted, was participating in the offense of kidnapping. If the state has proved all of the elements in either alternate theory, McKinley Louisma is guilty of murder in the first degree. If the state has failed to prove any one of the elements, McKinley Louisma is not guilty of murder in the first degree, and you will then consider the charge of murder in the second degree, as explained in instruction number 28. Instruction number 24. Willful means intentional or by fixed design or purpose and not accidental. To deliberate is to weigh in one's mind, to consider, to contemplate, or to reflect. Premeditate is to think or ponder upon a matter before acting. Instruction number 25. Deliberation and premeditation need not exist for any particular length of time before the act. Instruction number 26. Malice is a state of mind which leads one to intentionally do a wrongful act to the injury of another out of actual hatred or with an evil or unlawful purpose. Malice may be established by evidence of actual hatred or by proof of a deliberate or fixed intent to do injury. Malice may be found from the acts and conduct of McKinley Louisma and the means used in doing the wrongful and injurious act. It requires only such deliberation which would make a person appreciate and understand the nature of the act and its consequences, as distinguished from an act done in the heat of passion. Malice aforethought is a fixed purpose or design to do some physical harm to another which exists before the act is committed. It does not have to exist for any particular length of time. Instruction number 27. Malice aforethought may be inferred from the commission of a kidnapping which results in death. Malice aforethought may be inferred from the defendant's use of a dangerous weapon. Such intent may be inferred even though the wound inflicted does not prove fatal. A dangerous weapon is any device or instrument designed primarily for use in inflicting death or injury, and when used in its designed manner is capable of inflicting death. It is also any sort of instrument or device actually used in such a way as to indicate the user intended to inflict death or serious injury, and when so used is capable of inflicting death. Instruction number 28, count 1, lesser included offense. The state must prove all of the following elements of murder in the second degree. 1. On or about February 17-18, 2024, McKinley Louisma, or the person he aided and abetted, strangled Melody Hoffman. 2. Melody Hoffman died as a result of being strangled. 3. McKinley Louisma, or the person he aided and abetted, acted with malice aforethought. If the state has proved all of the elements, McKinley Louisma is guilty of murder in the second degree. If the state has failed to prove any one of the elements, he is not guilty of murder in the second degree, and you will then consider the charge of involuntary manslaughter by recklessness as explained in instruction number 30. Instruction number 29. Murder in the second degree does not require a specific intent to kill another person. Instruction number 30, count 2, lesser included offense. The state must prove both of the following elements of involuntary manslaughter by recklessness. 1. On or about February 17-18, 2024, McKinley Louisma, or the person he aided and abetted, recklessly committed the crime of assault. 2. When McKinley Louisma, or the person he aided and abetted, committed the assault, he or the other person unintentionally caused the death of Melody Hoffman. If the state has proved both elements, McKinley Louisma is guilty of involuntary manslaughter by recklessness. If the state has failed to prove either of the elements, he is not guilty of involuntary manslaughter by recklessness, and you will then consider involuntary manslaughter by conduct as explained in instruction number 32. Instruction number 31. An assault is an act which is intended to cause pain or injury or result in physical contact which is insulting or offensive or place the victim in fear of immediate physical contact which would have been painful, injurious, insulting, or offensive to the victim, coupled with the defendant's apparent ability to do the act. Apparent ability means a reasonable person in the defendant's position would expect the act to be completed under the existing facts and circumstances. As it relates to element 1 of instruction 30, a person participates in an assault beginning with the first act done towards the commission of the assault and ending when a person has been arrested or has escaped from pursuers. A person participates in a crime regardless if he is successful in completing it. Instruction number 32. The state must prove both of the following elements of involuntary manslaughter by conduct. 1. On or about February 17-18, 2024, McKinley Louisma, or the person he aided and abetted, recklessly strangled Melody Hoffman. 2. McKinley Louisma, or the person he aided and abetted, did the act in a manner likely to cause death or serious injury. 3. By doing the act, the defendant unintentionally caused the death of Melody Hoffman. If the state has proved both elements, McKinley Louisma is guilty of involuntary manslaughter by conduct. If the state has failed to prove either of the elements, he is not guilty of involuntary manslaughter by conduct, and you should find the defendant not guilty of count 1. Instruction number 33. Concerning element 1 in instruction numbers 30 and 32, a person is reckless or acts recklessly when he willfully disregards the safety of persons or property. It is more than a lack of reasonable care which may cause unintentional injury. Recklessness is conduct which is consciously done with willful disregard of the consequences. For recklessness to exist, the act must be highly dangerous. In addition, the danger must be so obvious that the actor knows or should reasonably foresee the harm will more likely than not result from the act. Though recklessness is willful, it is not intentional in the sense that harm is intended to result. Instruction number 34, count 2. The state must prove all of the following elements of kidnapping in the first degree. 1. On or about February 17-18, 2024, McKinley Louisma, or the person he aided and abetted, confined Melody Hoffman or removed her from one place to another. 2. McKinley Louisma, or the person he aided and abetted, did so with the specific intent to either A. inflict a serious injury upon her, or B. secretly confine her. 3. McKinley Louisma did not have Melody Hoffman's consent to do so. 4. As a result of the confinement, Melody Hoffman suffered a serious injury and or was intentionally subjected to torture. If the state has proved all of the elements, McKinley Louisma is guilty of kidnapping in the first degree. If the state has failed to prove any one of the elements, then McKinley Louisma is not guilty of kidnapping in the first degree, and you will then consider the charge of kidnapping in the third degree, as explained in instruction number 35. Instruction number 35, count 2, lesser included offense. The state must prove all of the following elements of kidnapping in the third degree. 1. On or about February 17-18, 2024, McKinley Louisma, or the person he aided and abetted, confined Melody Hoffman or removed her from one place to another. 2. McKinley Louisma, or the person he aided and abetted, did so with the specific intent to either A. inflict a serious injury upon her, or B. secretly confine her. 3. McKinley Louisma did not have Melody Hoffman's consent to do so. If the state has proved all of the elements, McKinley Louisma is guilty of kidnapping in the third degree. If the state has failed to prove any one of the elements, then McKinley Louisma is not guilty of kidnapping in the third degree, and you will then consider the charge of false imprisonment as explained in instruction number 36. Instruction number 36, count 2, lesser included offense. The state must prove all of the following elements of false imprisonment. 1, on or about February 17-18, 2024, McKinley Louisma, or the person he aided and abetted, intentionally confined Melody Hoffman. 2, Melody Hoffman was confined against her will. 3, McKinley Louisma, or the person he aided and abetted, did not have a reasonable belief that they had a right or authority to confine Melody Hoffman. If the state has proved all of the elements, then the defendant is guilty of false imprisonment. If the state has failed to prove any one of the elements, then the defendant is not guilty of count 2. Instruction number 37. A person is confined when her freedom to move about is substantially restricted by force, threat, or deception. The person may be confined either in the place where the restriction began or in a place to which she is removed and requires an intent to conceal or hide her or prevent her discovery. No minimum time of confinement or distance or removal is required. It must be more than slight. The confinement and or removal requires more than what is included in the commission of the crime of murder in the first degree. In determining whether confinement and or removal exists, you may consider whether 1, the risk of harm to Melody Hoffman was substantially increased, 2, the risk of detection was significantly reduced, 3, escape was made significantly easier. Instruction number 38. A serious injury is 1, a disabling mental illness, or 2, a condition which cripples and incapacitates, weakens, or destroys a person's normal mental functions, or 3, a bodily injury which creates a substantial risk of death, or which causes serious permanent disfigurement or extended loss or impairment of the function of any bodily part or organ. Substantial risk of death means more than any risk of death, but does not mean that death is likely. If there is a real hazard or danger of death, serious injury is established. Instruction number 39, concerning element 4 of instruction 34, torture means the intentional infliction of severe physical or mental pain and or the deliberate infliction of severe pain. Instruction number 40, count 3. The state must prove all of the following elements of conspiracy. 1, on or about February 17-18, 2024, McKinley Louisma agreed with Dakota Van Patten and or Logan Kimpton, A, that one or more of them would commit a murder or kidnapping, or solicit another to commit a murder or kidnapping, or B, attempt to commit a murder or kidnapping. 2, McKinley Louisma entered into the agreement with the intent to promote or facilitate a murder or kidnapping. 3, McKinley Louisma or Dakota Van Patten and or Logan Kimpton committed an overt act. 4, Dakota Van Patten and or Logan Kimpton were not law enforcement agents investigating the murder or kidnapping or assisting law enforcement agents in the investigation when the conspiracy began. If the state has proved all of these elements, McKinley Louisma is guilty of conspiracy. If the state has failed to prove any one of these elements, McKinley Louisma is not guilty. Instruction number 41, the state must prove McKinley Louisma, Dakota Van Patten, and or Logan Kimpton came to a mutual understanding murder and or kidnapping would be attempted or committed. The agreement can be oral or written, informal or formal, and need not be detailed, and may be proven by direct or circumstantial evidence of a person's words, actions, or gesture. Instruction number 42. Merely because 2 or more persons associate with each other or meet to discuss common interests or goals does not by itself establish an agreement or make one a member of a conspiracy. Instruction number 43. An overt act is an act indicating a person's intent to accomplish the offense. The overt act itself does not have to be a criminal act. An overt act alone does not prove a conspiracy. A person who commits an overt act cannot be found guilty of conspiracy unless that person also agreed and intended the offense would be committed. Instruction number 44. The state does not have to prove McKinley Louisma knew all the details of the conspiracy, nor all the other persons who had agreed to commit murder or kidnapping. However, the state must prove Louisma knowingly participated in the agreement at some time. If a person performs an act that promotes or facilitates the purpose of the conspiracy without knowledge of the conspiracy, he is not a conspirator. Instruction number 45. Whether a person is a conspirator depends upon his own conduct or statements. If, however, you find McKinley Louisma agreed the murder and kidnapping would be committed, then the conduct or statements of the others who agreed to commit those facilitated the purpose of the conspiracy and occurred before the conspiracy ended. It is not necessary the conduct or statements of the others occurred in Louisma's presence. Instruction number 46. Conspiracy is a crime separate from the crimes of murder and kidnapping. The offense itself does not have to be committed. Even if you find murder and kidnapping were committed, you cannot find McKinley Louisma guilty of conspiracy unless the state proves McKinley Louisma conspired to commit murder and kidnapping and an overt act was performed. Instruction number 47. A conspiracy requires an agreement between at least two persons. A person may be found guilty of conspiracy even though the person with whom he agreed has not been charged or tried. The remaining instructions will be read after the closing arguments. With regard to the reading of instructions, I just want to state for the record that in instruction 31, there was a typographical error. The word paint was there instead of pain. I read it correctly, and I've handwritten the correction to pain rather than paint. And then in instruction 38, there should be a period rather than a comma after the third numbered paragraph. And I corrected that with my initials. Is there any further record regarding the reading of instructions from the state? No, Your Honor. From the defense? Or, you may. Record on the reading of instructions is that at instruction 37, in the second paragraph, reading no minimum time of confinement or distance of removal, it should say of removal rather than or removal, and that has been corrected in the set of instructions that the jury will be receiving. Jurors, now is the time and place for counsel for each side to present their closing arguments. Counsel for the state will have the opening summation. Counsel for the defendant will then have an opportunity for reply. And since defendant will only address you once, they will present their summation. And then counsel for the state will have an opportunity to rebut the argument presented by the defendant. The counsel for each party will be summarizing the testimony that you've heard and the evidence which has been presented during the trial. They will merely be recalling the evidence that was presented, and they will not intentionally try to mislead you. And if their recollection of the testimony is not the same as yours, you must follow and rely on your own recollection. The summations of counsel are merely that. They're summations. They're not evidence, nor should they be construed by you as evidence or instructions on the law. And that's why you no longer have your notepads, because you're only allowed to take notes when evidence is being received. The summations are intended to help you in understanding the contentions of each side, and so I ask that you give each counsel your full attention. Is the state ready to give its closing argument?
Yes, Your Honor.
You may do so.
May it please the court, counsel. Ladies and gentlemen of the jury, depraved, dehumanizing, defies reason. The evidence in this case has shown that the defendant's actions, along with Dakota Van Patten, his accomplice, on February 17th and into the 18th of 2024, were depraved. The evidence in this case has shown that when they kidnapped, killed, and mutilated Melody Hoffman, they did it in a manner that can be described as nothing less than dehumanizing. We have laid out to you multiple reasons, possible explanations for why they did this. But as I'll talk to you about, and as you'll likely discuss among yourselves, all of the explanations still defy reason. Depraved, dehumanizing, defies reason. I said these words at the beginning of the case, and they still ring true. I have 3 more words for you now. Unbelievable, unreasonable, unsupported. This is not a case where Dakota Van Patten randomly decided to order his friend at gunpoint for 4 hours so he could tie up his ex-girlfriend, take a cruise around the county, and then strangle, slash, and stab her because she might have some money or because they had a disagreement about the music. Unbelievable, unreasonable, and unsupported by the evidence, and we'll get to that. Ladies and gentlemen, the evidence in this case has also shown that there is no conceivable way that the 2 of these people could have done this without the consent and support of each other. This isn't the type of crime that you weave in and weave out of throughout the course of the night, helping at times, resisting at others. The evidence in this case has shown the defendant was not an unwilling participant in this crime. Quite the opposite. The evidence in this case has shown that the defendant was the leader of this conspiracy. He was the instigator of the brutality that was inflicted upon Melody Hoffman. He was the key driver of the kidnapping and the only person in this case with true motive and passion to do what he did to Melody Hoffman. He may have needed Dakota Van Patten to help him. And Dakota Van Patten, ladies and gentlemen, is guilty of the role that he played in this too. Make no mistake. But none of this happens without the defendant. None of it. The evidence has shown in this case that the defendant and Dakota Van Patten worked in concert together from the time they walked into Walmart to buy the machetes and gloves to the time they went into Quick Star and got some celebratory cigars. You will find, and the evidence has shown, in this case, everything that was done required the cooperation of each other. And some actions literally required more than two hands to accomplish. Folks, we're almost there. It's been a long 2 weeks. We were here 2 weeks ago today when this started. It was Halloween. Now we're halfway between Halloween and Thanksgiving. Your patience has been appreciated. Please bear with us just a little bit longer here while we try to summarize for you the evidence in this case. And it might take a while. And please, if you need a break, let us know. And we'll do what we need to do. But this is an important part of the case. And I'm not going to leave anything out if I can help it. Can we have the PowerPoint up, Your Honor? On February 17th, 2024, Melody Hoffman was a vibrant 20-year-old young lady. She was still finding her way in the world. She was described by her mother as outgoing, bubbly, lively, caring, compassionate, would do anything to help anybody or any animals. The type of person that would walk up to you and compliment you on your ugly sweater just to see you smile. Melody lived with her mom and her protector, Megan Hoffman. You also heard that she wasn't a typical 20-year-old. Melody had an intellectual disability, a mild one, which caused her to have the maturity level of a person much younger than her, 14 or 15 years old, but in the body of a full-grown adult. Because of who she was, the type of person she was, she didn't always make decisions that were in her best interest. She was more susceptible to manipulation, overly trusting because she just wanted to feel loved. Melody would even trust strangers at times because she had no reason not to trust people. The type of person who would give her passcode to her phone, for example, if she thought she trusted you. At the time she was killed, she was still at home with her mom, while many of her peers from high school had moved on with their lives. But she was still very social, and she craved attention, wanted to have friends like anybody else. You saw that reflected in one of her last messages that she sent on Instagram, that she just wanted to have somebody love her besides her family. In particular, she craved the attention of young men and really wanted to have a boyfriend. And that's when the defendant came into her life. The defendant knew Melody very well. As of February 17th and 18th of 2024, he had been in a relationship with her, even stayed with her and her mother at their home. But he also had a lot going on in his life at that time. You see, he'd been involved in an even longer-term relationship with another woman who you heard from, Nakia Slobodha. And that relationship had lasted on and off for about 4 years. And there have been some struggles in that relationship, too. About jealousy, keeping jobs. The two of them split up in the middle of 2023. And then he started seeing Melody thereafter around October and November of 2023. But the relationship that Melody had with her first boyfriend was pretty short-lived. And the defendant and Nakia reconciled and got back together towards the end of December 2023. You see, among other possible reasons, the defendant got back together with Nakia. She was pregnant. He believed it was his child. As you also saw in the evidence, the defendant kept a pretty close eye on Nakia even when he was with Melody. Look at the Facebook searches. And we submit to you, you will find in those Facebook searches that he searched for her Facebook page 82 times in December 2023, showing where his mind was. So he got back together with the woman that he had a closer relationship with, and Melody broke up with the defendant in early January, around approximately January 6th. But instead of just letting her go, he strung her along. It was difficult on Melody because she knew the defendant wasn't good for her, but she didn't want to lose him. And the evidence in this case showed that these women also knew about each other. And that made it all the more stressful on them and on the defendant. This culminated in a blow-up with Nakia and an ultimatum by Nakia that to either end it with Melody or stay with her. But instead of letting her go, he continued to string Melody along, giving her hope they could get back together and taking advantage of Melody's feelings toward him, manipulating her. He even admitted that they hung out, and when they hung out, as you saw what he said, they had sex, which would explain the later findings that were made in the autopsy. And that secret that Melody had, in this case you should infer, we believe the evidence shows, it led to a boiling point. He had a lot going on in his life at that time. He had a long-term relationship. He was getting back together. He had a new girlfriend who he was starting to part with the secret. Then he had an ultimatum. On February 17, 2024, the evidence in this case has shown that the defendant had a past with Melody Hoffman and that she wanted to have a future with him, but he didn't. The evidence has shown in this case that instead of just letting her go, he decided the best way to handle this is to eliminate the impediment. You can ask yourself, why didn't he just let her go? That's a valid question. But unreasonable actions don't have reasonable explanations. It could be an intellectual endeavor. You could try. But he didn't do that, and he launched a plan instead. You see, Nakia had pregnancy complications early in the day on February 17th, and that added to his stress level. On that day, the defendant knew also that Megan Hoffman did not want him to be with Melody anymore, and he didn't want Megan to know that Melody was going to be with him. So they arranged to secretly leave her house that night, which is why Megan was surprised when Melody was out the door. He knew also, in order to execute his plan, which obviously entailed more than just killing Melody, as demonstrated by his later actions in this case, that he needed help. And he found that help in his co-conspirator, Dakota Van Patten. The original plan also involved another individual, Logan Kimpton, who would end up going home that night and not following through with the other two. See, the evidence in this case has shown that the defendant knew Melody very well. He knew that she'd be willing to get into the car with him despite all the problems they've had in their relationship, despite him having another girlfriend, despite there being someone she didn't know in the car. He knew she'd do it. He knew she would make that decision, one that was not a well-advised decision on her part, and a decision that would prove to be her last. The evidence in this case has shown that Melody Hoffman never came home again after this video. The state told you in their opening statement, if you remember, that we return to you at the end of this case and break down for you nearly minute by minute what happened in this case. And there was a lot of evidence of that. And your hands only work so fast. I get it. So I'm going to take the time now to show you what we believe is the timeline of this case. You can look at me or you can read, whatever you want. In 2020, the defendant met McKinley Louisma. And on their first date, they went to Lily Pond. On July 4th, 2023, the defendant, Nakia, broke up. And in October or November of 2023 is when the defendant met Melody Hoffman online and the two of them began seeing each other. From November 30th to February 12th of 2024, the evidence in this case has shown that the defendant searched or visited Melody Hoffman on Facebook 32 times. But in that same exhibit, you'll see that after February 12th, of 2024, there were no more searches or visits to Melody Hoffman. An insight into where Melody Hoffman ranked in his mind at that point in time. From December 16th to February 19th, the defendant searched for Megan Hoffman 17 times, only 7 times before January 7th, 2024, when they broke up. And then the timeline in this case showed that in later December of 2023, the defendant got back together with Nakia Louisma, who was pregnant with what he believed to be his child. Then on January 5th, 2024, the defendant removes Melody as a friend on Facebook. We heard that testimony. And on January 6th, 2024, the defendant and Melody Hoffman broke up. On January 6th, 2024, at 11:36 and 48 seconds p.m., the defendant realized that a Facebook account that he was talking to with the name Maddie Brown was actually Melody, and continued the conversation with her by saying, "Melody, if you texting me, you can stop because clearly you don't have nothing better to do." Further on, saying in the message at 11:37 and 11 seconds, "I don't want to play whatever game you're playing because I'm not interested." And then at 11:40 and 16 seconds, Melody blows her cover, says, "We're going to throw away your stuff." This is evidence of the conflict that was happening at the time the two of them broke up. Then on January 7th, 2024, Nakia goes with Ken to pick up the defendant, to go pick up stuff from Melody and Megan Hoffman's residence, and describes that he was upset. There were some things that were left outside. And then on January 7th, 2024, at 8:27 p.m., Melody receives a threatening text message from an unknown text now number. I'm not going to read it all, but it refers to her being a dead girl Cops aren't going to protect her. Calls her a retarded ass bitch. Says you're not going to be safe. Efforts to determine whose account this came from were unsuccessful. But the circumstances show, based on Melody Hoffman's life, who she was associating with, the limited number of people she would associate with, that this evidence came from, we submit to you, the defendant, this text. On that same day, defendant searches for Megan Hoffman 3 times. After this, you heard in this case that the breakup was hard on Melody, as I've already mentioned. See, the defendant was her first real boyfriend. She wanted to be with him. She couldn't stay with him because he wasn't valuing her. Meanwhile, on January 8th, we see at 3:51 p.m. that the defendant visits the Facebook account of Coda Smith, who we learn in this case is Dakota Van Patten. We know that the defendant has known Dakota Van Patten up to the time of February 17th and 18th for about 40 days. He ends up doing it again, searching again on January 12th and 16th. And then on the 15th, he does one search for Megan Hoffman. So you can see that Melody/Megan's still on his mind following that breakup. The timeline in this case shows that on January 26th, 2024, at 7:39 p.m., there's a conversation that's followed by an ultimatum. And that conversation takes place between Melody and either the defendant in Nakia, the defendant or Nakia. But it's clear from the circumstances that it's one or both of them that takes place at that time. Starts with a video chat, audio call, and then, why are you calling my name like that? Because you mad he's with me? Seems like that's probably from Nakia. Melody replies, you probably don't want to be with me, and now you're ignoring me, and you have no reason to do it. There's some more exchanges of audio and video calls. Melody says, Ken, WTF, a missed call, an audio call, and then Melody saying, tell him I'm done with this goofy ass, and then a statement back, how can you be done with somebody who's already done with you, with a bunch of laugh emojis back at Melody. And she says, don't even think about coming to my crib or my grandparents' house. I don't want you around here. Have fun with Kia and adios, amigos. So she appears to be essentially done with him at that point in time after that conversation. Within the next couple of weeks, we're up to February 14th, 2024 here, the defendant appears to be more focused on Megan Hoffman. Searches for her on Facebook on February 15th. Before that, on February 14th, he's searching for a machete at the Walmart. Takes a screenshot of it. We see it in his phone records. This is 3 days before the mudding camping adventure in February they apparently were going to take. Then on February 16th, he updated his cover photo. And on February 16th, he visits Megan Hoffman again. And on February 16th, we hear that was the last time that Megan knew that the two of them talked, was on February 16th. It's Friday. We're up to the Friday at this point in time. And now we can move on to February 17th at 2:56 p.m., which the evidence shows the defendant purchased a digital doorknob at that point in time. Then at 11:32 a.m., he searches for a machete at Walmart. Well, that's what we did in the previous slide. Melody starts messaging the defendant on Instagram. uses the pet name that she has for him that we learned here. She calls him Bubby. So apparently they're back on some kind of good terms at this point in time. And she says, Ken, and she says, why are you ignoring me? That night they get home around 6 p.m. from going to Sam's and Aldi's and Starbucks, start putting the groceries away. And at 6:24 p.m. we see through phone records that Mr. Louisma is at St. Luke's hospital in that area with Nakia. And then Melody reaches back out to him 3 more times after that. Why are you ignoring me? Hello? Bruh, answer your phone. It's on him. Hey, respond to me. Well, he's going through this extra stress at the time. And then on February 17th, we see that his device begins to travel from the mobile home community where he lived at the time, near North Center Point Road, in the direction of Southwest Cedar Rapids. On February 17th, 2024, that's when Melody sends the message to another individual on Instagram, giving us a view into her state of mind and her decision-making. In this case, that she just wants a fucking person who actually fucking loves her besides her fam. And then from about 9 to 11, Megan described the two of them watched a movie. By February 17th at 9:48 p.m., Mr. Louisma's device is near the Southwest Walmart in Cedar Rapids, per that location data that Jeff Holst told us about. While he's there, you can't see it because it kind of gets down to the bottom here, but you can see quite clearly the images on top. Purportedly, while he's in the parking lot at Walmart, he views pictures of 11 different face coverings and accesses, we believe you'll find in those records, 23 different images of face coverings. Rubber gloves, heavy-duty gloves, and what can only be described as ominous online behavior, particularly in consideration of what takes place within hours after that. Ladies and gentlemen, we submit to you that what you see here is not evidence of going mudding or sort of camping. It's evidence of a plot, a conspiracy. Then on February 17th, 2024 at 10:06 p.m., defendants observed with Dakota Van Patten and Logan Kimpton at Walmart, as we saw previously, purchasing the machete and the gloves. Mr. Louisma is leading him out the door to the parking lot where he ends up going into that trunk, which would later reveal some significant evidence in this case. Ladies and gentlemen, you've received instructions on conspiracy. In this case, the state has to prove to you that on or about these dates, and when we say February 17th to 18th, we're covering everything here. It could happen on 17, could happen on 18. Spanning those dates, that one or more of these people, Mr. Louisma, Van Patten, or Kimpton, conspired and agreed they would commit a murder or kidnapping or solicit another to commit it or attempt to commit a murder or kidnapping. That Mr. Louisma entered into that agreement with the intent to promote or facilitate that, which we saw was clear from the actions in this case and the evidence leading up to this. And that one of them committed an overt act. We just saw evidence of all of them committing an overt act early in the conspiracy, but the overt act can take place at any time after that. And that they were not law enforcement agents investigating the murder or kidnapping. Well, clearly, these individuals, Mr. Kimpton and Mr. Van Patten, were charged with crimes. They're not law enforcement agents. And if we proved all that, we've proved the defendant guilty of conspiracy. Back to the timeline of the case, on February 17th at 10:23 p.m., we see that Dakota Van Patten takes a selfie, apparently and obviously within the same vehicle as Mr. Louisma, with the BB gun tucked in his waistband and some sort of text about him laughing as he did it. This is happening, ladies and gentlemen, right in front of Mr. Louisma. He's driving the car. Yet he later proclaims to be surprised by the presence of a gun, and even describes the wrong gun, too. We'll get to that. Moving on to the timeline of the case, defendant and Van Patten then pick up Trevor Weiss. You heard from him. They take him from work at Lebowski's back to the same trailer park where everybody else lived, the Tower Terrace trailer park. And in the car, the defendant says to Trevor, "Don't tell Patty that he and Van Patten are together because they tend to get in trouble." And about the same time, around 11:15, that movie that Megan and Melody were watching wraps up for the night. Megan thinks that, well, I guess we're going to bed now. Surveillance footage in this case gives us more information on the timeline. At 11:17, the defendant and Van Patten were at the corner of C Avenue and Collins Road. At 11:17 and 55 seconds, they were passing Northland Drive, still on Collins Road. At 11:18, they were passing Lyndale Mall. And at 11:18 and 36 seconds, which is about what you see here, they're passing Twickstown Road and continuing eastbound on Highway 100 toward Marion and toward Melody's house. We also see at 11:22 p.m. that Louisma is in the area of East Post Road, Meadowview Drive, and South 12th Street, where Melody lives, within about 2 minutes from the time he picked her up. We see on February 17th at 11:23 and 46 seconds that Melody sends a Snapchat message to the defendant. "How long are you going to be?" "Not long." "You want to just meet at the Casey's?" "Just to Wendy's." "Okay. The one by us is closed." "Yes, just come where I always be." "Hurry up." "Okay." Secretly planning to take Melody from her residence that night without her mom's knowledge. "Meet me somewhere else." Things are so great if the defendant has this positive relationship with Megan and their family. Why was this done in secret? Because he didn't want Megan to know that Melody was going with him. Then at 11:24 p.m., the blink camera system at the Castle de la Hoffman shows that Melody leaves the residence for the night and is receiving messages as she leaves, as we saw in that video a few moments ago. At 11:27 p.m., these are State's Exhibits number 10B. You see that Megan texts Melody. 11:29, her phone's already hitting off a tower near her home as she leaves the residence. Continues to hit off that phone minutes later as they're on Highway 100 westbound, just almost to Edgewood Road at that point in time. And that Melody's phone continues to hit until it gets to Morgan Creek Park around 11:58 p.m. And then at 11:59 p.m., right when they got to Morgan Creek Park, that's when Van Patten takes a photo with his Snapchat app of those set of 4 numbers that we found out was Melody Hoffman's passcode. Consistent with a scenario where Melody gave it to him, he opened the phone, took down the number, probably as part of the conspiracy to come. But at that point in time, we submit to you that based on the defendant's story that he told, Dakota Van Patten didn't get the passcode in the way he said it happened. Watch his interview. He said that happened after they left Morgan Creek all the way over at Marion. This is, well, things are still cool. So here's the messages. Are you kidding me right now? She says, I'll be back. They talk about the key. She says she doesn't unlock it. Megan says, well, it's locked now. Text me when you want in. Don't be too late. Don't lose your ring. What time are you coming home? And Melody says, I don't know, Mom. I don't know. Then at 11:40 p.m., Melody sends a Snapchat video out to her, Snapchat friends, however that works. And Megan sees it.
Why not? Niggas ain't worth my energy.
Melody Hoffman had no idea what was going to happen next. We see at 11:58 p.m. to 12:02 a.m. that State's Exhibit number 17AA shows that Melody is in the area along a trip between Cherry Hill and Morgan Creek Park. And that from 12:03 to 12:33 a.m. that her phone is hitting off a cell tower that's just northeast of Morgan Creek Park. But in between those events, you'll see it hit off towers that were south and east of Morgan Creek Park, closer to Cherry Hill. Consistent with a path of travel of Cherry Hill to Morgan Creek. While this is all going on up till 12:02 a.m., 3 minutes after Dakota Van Patten got the passcode, they're still en route to Morgan Creek Park. And then, we don't have the specific date or specific time, but we know that an event took place during that midnight hour at Morgan Creek Park. Because we looked at Melody's Apple Health data, and it revealed that there was an event that was either connected to a high decibel event or some other physical event that caused her heart rate to elevate. And that Apple Health data then revealed that her heart rate either stopped or the watch was removed at that time. In any event, it showed it went from a resting rate immediately to a heart rate that was elevated. And then we saw for Mr. Louisma's phone, health data. First, we saw that his device was on the south side of Morgan Creek Park in the parking lot between 12:09 to 12:19 a.m. This is small, but you'll get a chance to look at this when you break it down in the jury room. And that during that time period from 12:09 to 12:19, he took 28 steps covering 44 meters during that 9-minute period. Enough time to get out of the vehicle, move around. And that from 12:19, so almost immediately, just a 10-second break there, until 12:28, he took another 29 steps. Investigators did some follow-up on this, and they found that it takes 39 steps to get to the pavilion and 46 steps to get back from the back of the pavilion. And that 39 steps equates to 32 meters. All numbers that are consistent within movement between the vehicle and the pavilion during that period of time. But nonetheless, it shows the defendant out of the vehicle, moving around. So we know the defendant was out of his vehicle. We know Melody was there. We also know that when they arrived at Morgan Creek Park, that Megan Hoffman was watching Melody's location. And she determined what she pretty much already knew, that Melody had to be with the defendant because she knew they had been there before. Melody brought a cat home, if you remember that testimony. The evidence in this case has shown that the defendant and Van Patten drove to this dark and secluded park, and that's where this fun night turned fatal. That's where the carefreeness and levity turned into depravity. The evidence in this case has shown that at Morgan Creek Park in Lynn County, Iowa, during the midnight hour, whatever depraved plan the defendant and Dakota Van Patten had came into action. Melody was beaten. While beating her, the evidence in this case has shown that they used a handle of a machete across her face, as you saw in the evidence presented through the medical examiner. The evidence in this case showed that they tortured and terrorized her at this time, beating her, bound her with duct tape around her mouth, around her hands, and we submit to you her feet, as those pictures later showed. These injuries to the top of her head, deep contusions, brutal beating. Look at the definition of torture. It was at that point in time they then removed her from Morgan Creek Park and headed back toward Marion to carry out their sadistic plan. Whatever reason they had, we'll visit that again, for terrorizing, tying up, and kidnapping Melody Hoffman, the evidence has shown that that reason was depraved and it involved dehumanizing her. They didn't treat her as any human being ever deserves to be treated. She was subject to unspeakable horror and terror throughout this whole process. Beaten, bound, back of a vehicle, not knowing where she was going. Subjecting her to severe physical and emotional pain. That's the definition of torture. And how do we know that they did this? Because he documented it. Data from his device, you heard, showed that when he was at Morgan Creek Park, the camera app on his phone was activated upon arrival and right before leaving. Again, you might ask yourself, why? Why did they do this? We submit to you that you can answer that question by where they went next. And the evidence shows that they went to Melody's home and tried to make contact with Megan Hoffman. And if that's not the reason, then the reason's so depraved we can't even contemplate what it was. Talk about some instructions here. This is an important one, ladies and gentlemen. This instruction says where two or more alternative theories are presented, or where two or more facts would produce the same result, the law does not require each of you to agree as to which theory or fact leads to your verdict. It's the verdict itself that must be unanimous, not the theory or the facts upon which it rests. What does that mean? There's evidence in this case that shows Melody Hoffman was potentially killed at Morgan Creek Park. There's evidence in this case that shows that she wasn't. We believe the evidence shows that she wasn't. You can believe she was. There's evidence in this case that McKinley Louisma did some things. There's evidence in this case that Dakota Van Patten did some things. And we'll talk about aiding and abetting here in a moment. Whatever leads you to find that the defendant in this case committed kidnapping and murder in the first degree, whatever fact it is, it doesn't have to be one you all agree on as long as you agree that he committed the crimes. That's what this means. And let's look at this aiding and abetting instruction in number 16. As used in the instructions relating to counts 1 and 2, aid and abet means to knowingly approve and agree to the commission of a crime either by active participation in it or by knowingly advising or encouraging the act in some way before or when it is committed. The evidence shows clearly there was active participation and encouragement between these two and active participation. This is the checklist that we talked about a week ago today or so for kidnapping in the first degree. We have to prove to you, and we have in this case, that on or about February 17th and 18th, that the defendant or the person he aided and abetted confined Melody Hoffman or removed her from one place to another. That is clear as day in this case, that Melody Hoffman was confined and removed from one place to another, and that the defendant took an active role in that, as did Dakota Van Patten. We have to prove that the defendant or the Dakota Van Patten did so with the specific intent to inflict a serious injury upon her or secretly confine her. You just saw those injuries. You've seen the later injuries that we haven't got to yet. And clearly, when you put somebody in the trunk of a car, you're secretly confining them. That they didn't have her consent to do so, obviously. And as a result of that confinement, she suffered a serious injury or was subjected to torture. We talked about torture already. Here's the definition of serious injury: conditions that cripple, incapacitate, or weaken or destroy a person's normal mental functions, that which would cause disfigurement, a substantial risk of death. All these injuries that you saw, we submit to you on Melody Hoffman, meet this definition, including the injuries that led to her death. Here's that definition of torture: intentional infliction of severe physical or mental pain, deliberate infliction of severe pain. And then here's a definition on confinement: freedom to move is substantially restricted by force, threat, or deception. Person may be confined either in the place where the restriction began or in a place to which she is removed. No minimum time is required. I think we changed that minimum time of confinement of distance or distance of removal. We did some change to that jury instruction. Follow the one the judge gave you. It has to be more than slight. Clearly, we have two separate events in this case: the beating, the torture, the kidnapping, the infliction of serious injury, and then later on the murder. Or if it happened at the same time, it's still separate events. Back to the timeline in this case. We found that Melody's phone hit for the last time near Morgan Creek at about 12:33 a.m. And then Louisma's device moves out of Morgan Creek. Melody's phone hits off the tower at Highway 100 at 12:41. And then starting at 12:49, Melody's phone hits off towers near her home in Meadowview area, or Meadowview Drive area. At the same time, at 12:58, Van Patten's phone is also hitting off that same area. So by 12:54, they're back in the area of Marion near Melody's home. As they drove toward her home to carry out this plan, the evidence showed they stopped in a parking lot area. And while Louisma, the defendant, is traveling back into Marion, we see that he searched for Hannah Park in his phone. Melody's phone's still hitting off the same tower in that area. And then at 1:01 a.m., it connects to Dakota Van Patten's hotspot, showing both people participating at this point in time in the execution of this plan. At around 1 a.m., there's a Snapchat conversation that starts with the defendant and Dakota Van Patten and then continues saying that they're on their way. Leave the door unlocked. Megan says, turn your location on. I'll get up and open it. Okay, then he says, I'm down the street. What are you doing down there? Seeing a friend. Get out of there, says Megan. Not trespassing. Landlord won't care. Call and talk. So on and so forth. As you see in this conversation, Megan immediately noticed that the location on the phone was off and told her to turn it back on. While this is happening, you've heard evidence in this case and saw that the defendant and Van Patten encountered a Marion police car. And that at approximately the same time they did that is when the location on Melody's phone was turned off. We heard that Marion Police Department record shows that Officer Stark was dispatched at 1:12 a.m. to that area of Meadowview Drive, and that he was traveling southbound on 11th Street and approached the intersection with Meadowview Drive and passed right by Louisma's vehicle that was turning northbound from Meadowview Drive, going in the direction of Hannah Park. And at 1:17, Melody's phone last hits off the tower in the area. You heard the defendant's story of what he was trying to do at this time, trying to get the attention of anybody. Help Megan, or help Melody. Drove right by a police car. Nothing. Didn't do anything. Except for turn off the location of the phone and leave the area. We saw at 1:17, that's when the conversation with Megan continues. And from 1:17 to 1:21, her phone's hitting off the towers. They send the Late Night Vibes video. She says, hey, turn it back on. Location, I already saw that. Door is locked. Text me when you're coming in. And then we see her efforts to try to figure out where her daughter was after that. While she's still watching her daughter's location, wondering where she was, she's still receiving these messages from Snapchat. The evidence in this case has shown it couldn't have been Melody. We talked about how this had to be done in concert with each other. The evidence in this case shows it was likely the defendant that was making these communications with Melody's phone, happening right in front of and in concert with Dakota Van Patten. His phone's hitting off a cell tower near 7th Avenue in Marion. Let's look at the defendant's texts. Texts that we know came from him. On January 7th, okay, thank you. Am allowed to come get them right now? 4:35, M here. Down on the bottom, when he's talking to Maddie Brown, I don't want to play whatever game you're playing because I'm not interested. I'm on my way. I'm not trespassing. It's a unique form of texting that matches up directly to how the defendant speaks. The defendant was the one talking to Megan. The defendant who was trying to get Megan's attention. Let her know they were in the area. Get some help. The defendant who couldn't find his phone. Had a phone in his hand. Timeline of the case continues to 1:26 a.m. When her phone hits off a tower, they're going westbound near the I-380 interchange and Highway 100 at that time. Then at 1:29, Dakota Van Patten's phone indicates they're in a cell tower around the river on Edgewood Road, heading south on Edgewood Road. Melody's phone hits off the same towers, and then Dakota Van Patten's phone is also captured off those towers as they turn towards Highway 151 and then south of Walford. Meanwhile, taking a break from this timeline, we get back to Logan Kimpton. Remember him? Logan Kimpton's phone shows that he has left the area of his home at about 2:01 a.m. And his phone's hitting off towers north of his residence near Robbins Road. We heard testimony in this case that during that night, Logan Kimpton was with Brandon Monson. Remember Brandon? There's been a lot of witnesses here. Brandon came in here, was here for a short period of time. But what he had to say was pretty important. Brandon Monson said that Logan Kimpton was talking about how he, Ken, and Dakota have a plan to kill someone, and it was supposed to happen that night. That's not just a convenient thing or a joking thing to say, given what we know happened. And the evidence supports it. Back to the timeline here, we see Mr. Louisma's device then begin to head southwest past Walford. Melody's phone hits again past Walford at 2:04 a.m. Then at 2:05 a.m., Van Patten's phone hits off the same tower south of Walford. And then at 2:06, her phone's hitting off Lily Pond. Mr. Louisma's device also shows he's in that area by 2:10 a.m. And then at 2:15 a.m., he is in the green space area right outside the parking lot on Lily Pond. Back to this health data. We see that at this point in time, the data from the health data app and the defendant's phone shows there's an event that lasts 8.44 minutes, and during that event, the defendant took 320 steps, or 185 or so meters. And in this case, you heard evidence of what happened next. And again, you might want to try to understand why. But what you saw was shocking. And it defies reason. You'll see, the state submits to you, the evidence in this case shows, and you should infer, that the defendants, having just been in the area of Marion, having just been trying to make contact with Megan Hoffman, getting spooked out because there were police in the area, left the area and decided things had gone too far. We got to end this. We don't want to get caught. We don't want her to tell the police what happened. Could have been part of their plan the whole time. But this is the part of the plan where those actions took place. They arrived at Lily Pond, and they used this paracord to strangle Melody Hoffman. DNA findings, I apologize for the small writing here, but you have these reports and evidence. DNA findings show 3 individuals handled this paracord. You can see it right down here. The DNA developed from the shorter tail of the paracord indicated a mixture of 3 individuals. In some places there were 2, some places there were 3. In any event, DNA shows handled by 3 people. We don't know who those 3 people were besides Melody, because there wasn't enough DNA to be able to make that comparison, but we know that there's 2 people's DNA on there. We also know that somebody in this case admitted to touching everything. So we know that one of those persons' DNA is the defendant by his own admission. The stress of the defendant's life caught up to him. The ultimatums, the pregnancies, the past conflict, the plan they had that didn't work out, the need to eliminate the impediment, the need to eliminate the witness. This is a photo taken at autopsy. and you heard about the force that's required that would need to be enough to cause these abrasions to the skin, the hemorrhages to the neck, the damage to the blood vessels. A strangulation event is an extremely violent event. This is evidence of the force that was used, digging the paracord into her neck, reducing the blood flow to her brain, preventing the oxygen from going to her brain, making her unconscious, and then killing her. This, we submit to you, is an action that not only requires malice, the intent to kill, but is also an action of passion. An action taken by somebody who has passion involved in it. Not somebody who's upset about the music. Unless they're just helping out. Here's some DNA evidence that you heard about the knife. The DNA profile developed from the scalp, bottom, and back edges of the knife indicated a mixture of 3 individuals. One of them is Melody Hoffman. There were 3 people out at Lily Pond that night. Melody Hoffman, the defendant, and Dakota Van Patten. And we know the defendant touched the knife because he told us he did. These are the steps in the health data app that shows what happened at that point in time. An event 8.61 minutes long, involving 251 steps. Less steps involving someone who's more in a hurry to get something done. And during that time, we submit to you the evidence shows that's when the knife was used, based upon what we'll see next, the injuries to Melody Hoffman. Injuries that Dr. Cruz said were likely in the peri-mortem or post-mortem stage. Same thing she said about injuries to her hands as well. Could be peri-mortem, could be pre-mortem, probably peri-mortem, post-mortem. As demonstrated by how they appeared, a lack of significant blood, the yellowing that's taking place. We matched up that knife to the injuries in 24-0. 30 cuts, 5 stab wounds. We submit to you done in order to make this look like it was some kind of attack that led to her death. Staging the scene. This is inflicted in order to kill her, but they definitely show evidence of the use of this dangerous weapon and what's in their mind at the time. We also had data from the defendant's device that showed at this time that his camera app was open right before they left Lily Pond. We saw in the forensic data that later on, we'll get to that, the defendant deleted not 1 but 2 photos. Or items from his photo gallery. Ladies and gentlemen, the evidence in this case showed that the defendant, with Dakota Van Patten by his side, strangled Melody, stripped Melody, mutilated her body, and left her for dead on the shores of a chilly, rural pond in Iowa County on a cold February night. The evidence in this case shows there were different possible reasons. The animosity from the breakup, the ridding himself of Melody and her unborn child, the twisted plan that involved Megan, a person that they knew would be watching her, the realization that they had gone too far. These are all potential reasons, individually or in combination, for this happened. And if they weren't, they can only be so depraved and senseless we can't fathom them. The evidence will show this happened, and they left her for dead during that 2 o'clock hour. These are the elements of murder in the first degree. This is the checklist. The state has to prove to you that, again, on these dates, anytime in these dates, that Mr. Louisma or the person he aided and abetted killed Melody Hoffman, strangled Melody Hoffman, and that she died as a result of being strangled, and that they acted with malice aforethought, that they acted willfully, deliberately, premeditatedly, and with a specific intent to kill. We have demonstrated to you in this case the defendant and or Dakota Van Patten did this, that she died as a result of it, and that they acted with malice aforethought, and based on all the evidence of the planning that took place and of the crime itself. You don't dig a rope into someone's neck if you don't have an intent to kill them. And the premeditation doesn't have to be in any certain length. This is first-degree murder. Remember that theory about, or that instruction about the alternative theories, though. Here's another checklist. Again, you don't have to agree on the theory of murder first, as long as you agree that murder first happened in one of these ways or with a combination of facts that get you there. We have to prove that on February 17th and 18th that the defendant or the person he aided and abetted strangled Melody, that she died, they acted with malice aforethought, and they were participating in the offense of kidnapping when they did it. That's called felony murder, forcible felony murder. So just by the mere fact that they were participating in this kidnapping and had malice aforethought while doing it, that is murder in the first degree as well. Here's malice aforethought definition. It can be inferred from the kidnapping itself. You can infer malice just by what they did to get to this point, to kidnap her. The use of the dangerous weapons in this case, and we submit to you that the way the rope was used could be a dangerous weapon. There's machetes. There's also a knife. There's your definition of dangerous weapon. Back to the timeline in this case. The last event that we saw happen near Lily Pond was at 2:35 a.m. when it appeared they were moving out of that area to Walford. And Mr. Louisma's device was moving back in that general route, north through Walford, ultimately to Edgewood Road. You heard from testimony from Jeff Holz that Mr. Louisma's device showed that on the way back from Walford, or from Lily Pond, he was playing YouTube music. The phone that could have been used for help at any given time, at that time, maybe even, a phone that was out of reach. As soon as he got, first thing he did was put on some music. He'll call the police. And Melody's phone continues to hit off that tower between Walford and Fairfax, goes north of Fairfax, connects to Dakota Van Patten's hotspot at 252, and then hits off the tower southwest of Walford, showing their movement is gradual out of that area. We also saw a video of the defendant's vehicle pulling into BP. Now we submit to you, based upon the locations in the phone and where we knew they were, that the time in that video has to be off because it's around the 2:30 area, because we know that's where they were at Lily Pond at the time. But it still shows the defendant's actions as he pulled into the BP. What he described as trying to get the attention of officers, but it's just a slow roll through there. Like somebody's trying to potentially avoid an officer, avoid being detected. Timeline of the case continues here, and it captures Mr. Louisma with Mr. Van Patten as his passenger. This is the area of Edgewood Road, and I believe this is 33rd Avenue, where you can see an object in Mr. Van Patten's hand, which we would submit to you as probably Melody Hoffman's phone. But it could be a number of things. 3 a.m., Louisma's phone hits off a cell tower near 16th Avenue, so they're continuing going north on Edgewood Road. And at 3:04 a.m., they're continuing northbound, and the last time the vehicle is seen at that time on Edgewood Road is at Edgewood and Ellis Road. Then at 3:10 a.m., we saw through Melody Hoffman's cell phone tower location records that at 3:10 a.m. there was a bunch of events that started happening that extended all the way out till 5 a.m., showing the phone and its location there being thrown out, where it was ultimately found, at the entrance ramp onto Highway 100 from Edgewood Road. And evidence of people trying to contact her and the phone doing what the phone does. February 13th, travel continues on Highway 100, east to ultimately the area of Quick Start, Blairs Ferry Road. And then at 3:12 a.m., the Louisma vehicle is seen at the intersection of Council and Collins. Again, seen at Collins and Rockwell. And then at 3:13 a.m., in 1 second, there is a selfie that's taken by Van Patten of him wearing Melody Hoffman's glasses. Right next to the defendant. The defendant who was so upset what just happened. Meanwhile, there's his friend taking selfies right there. At 3:13 and 15 seconds, then the vehicle continues as Van Patten's phone hits off a tower on Blairs Ferry and C Avenue, and then the traffic camera surveillance picks back up at 3:13. Then at Collins and F, they're turning northbound. What we see when they're going on to Blairs Ferry Road from C Avenue is the mint green bag in the back seat. Pretty good surveillance footage. You can even see the color of it. While that's happening at 3:13 and 26 seconds, there's a crash alert. We heard evidence that showed what events could happen that would trigger that. Crushing event, some kind of loud noise event. So even though the phone had been there for about 3 minutes, it wasn't until 3 minutes later when likely a car ran over or some other event happened that finally prompted that crash alert. And then at 3:15, defendants are last seen on the roadway going to the Quick Star, and then they pull into the Quick Star at 3:17 p.m., that's the top left. For nearly 4 minutes, they're in the store. They're still at the counter, buying some smokes. Looks like they're in no hurry. There's no distress, just based on wanting them. And then they head to the bathroom around 3:21 and 42 seconds with Mr. Louisma leading the way, heading in there to wash up. The evidence is shown after brutally terrorizing, torturing, kidnapping, killing Melody Hoffman. Mr. Louisma used $20, bought some cigars and some cigarettes. Then they leave at 3:24 a.m., again with the defendant leading the way, and they take the mint green bag, the defendant takes the mint green bag, we submit to you that's what the evidence shows in this case, out of the back seat and moves it to the trunk. Gets into the car, drives away. I'm probably not going to spend a lot of time talking about the defendant's interviews. Maybe later, we'll see. But if you recall, when he was first asked by Special Agent Kedley whether they would find any evidence of Melody in the car, For about 6 minutes or so, he danced around talking about, well, there might be a bag, had my girlfriend's clothes in it, you know, some trash, some garbage. Well, yeah, but my question was, what about Melody? Well, there's this bag, my girlfriend's clothes, she trashes my car, you know. Okay, what about Melody? I was thinking maybe some shoes and garbage, gloves and garbage, I think is what he says. When he comes in for that interview, the defendant knows very well what's in that bag. He just didn't want to say. But he also said he couldn't wait to tell somebody what happened. At 3:29 and 4 seconds, Megan messages defendant from Melody's Instagram and says, hey, this is Megan, is Mel with you? And at that time, we see that he's still with Mr. Van Patten, and they're going north on C Avenue to Boyson Road and ultimately to Marion, to the Bentley Drive apartments. They arrive at the Bentley Drive apartments at 3:36 a.m. That's where the defendant drops off Van Patten. We see that's at 3:36 and 24 seconds, and around the same time, the only thing you saw, what you saw from defendant's Van Patten's phone here is a picture that corresponds with being at that location. And then back at around 3:45, defendant's heading west on Boyson Road back home to Hiawatha. You heard that Van Patten at that point in time talked to Taya Meyer. That he arrived at the residence, called her, she came down, said, what's up, what's going on? Says, I got to talk to you, let's go inside. They go inside. They go into her bedroom. He says, I killed someone. What do you mean, what happened? Who? That Melody girl, the Melody. Ken and I killed somebody. She says, what are you talking about? You need to get out of here right now. Why'd you do that? It had to be done. All statements that fit exactly into what happened in this case. And ladies and gentlemen, I would submit to you, if Dakota Van Patten was the criminal mastermind that was described by Mr. Louisma, who forced him for 4 hours at gunpoint to perpetrate this violent, horrific crime, made him touch all the evidence, threatened him if he told anybody, why in the world would he confess to the first person he saw? Doesn't make any sense. Which means the story doesn't make any sense. It is a guilty conscience, though. At 3:49 a.m., defendant is heading back to the mobile home community, arrives at Hummingbird Lane, and at 3:49 a.m. we heard Nakia describe what happened when the defendant got home, that he got home, that he was shaking, he gave her a kiss, she smelled smoke, he said he loved her, and then he got to looking at videos, she said. Meanwhile, at 3:58 a.m., the defendant hadn't responded to the message that Megan Hoffman sent to him on Instagram, but at that point in time, we see initially that he does send one back. And so remember, she was talking from Melody's Instagram page. So instead of responding to Megan, he responds to Melody, knowing that she's dead. Hey, your mom's trying to get a hold of you. Is you okay? And then again at around 4 a.m., your mom's texting you. But before he gets to that last message, he's on Snapchat, then he's on Facebook, then he switches back to Instagram, sends those messages. So we can see exactly what he's doing with his phone at this point in time. And then there's a report and evidence, digital forensic examination report you can look at. And it will show you what happened at that point in time in reference to a photo that we've already shown that was downloaded or populated, whatever the term is, to his phone at that time. He switches to the photo gallery. He's on the screen. It shows that he's interacting with the photos. There's an overlay event, which is like a screenshot or, bringing up, I think they call it the carousel. You remember he said? But there's an event that the photo comes out and there's a photo overlay, likely a screenshot being taken, as Investigator Hull said, or that he's using the carousel. Defendant decides not to interact with the new application, goes back to the photo gallery, and then deletes a photo. And then deletes another photo. Then accesses the deleted album using biometrics, Face ID, and then deletes items from there. And then the photo gallery app ends at that point in time. And this all surrounds what happens after that last move. And at 4:05 and 32 seconds a.m., the picture of Melody Hoffman duct taped around her mouth is saved into his phone, the picture he was just interacting with. He didn't know that was going to happen. He tried to delete that, didn't he? But the phone, it does things for you to make your user experience better. Saves it into an app intents folder. Maybe you want to send this to a friend. Maybe you want to send it to Facebook Messenger, to Snapchat. We're going to save it for you, just for a while. Just long enough for it to be found. And then right at that time, Facebook Messenger becomes his application, and he receives messages that says, good day, and yep, from wifey. We're to the morning time. We heard the defendant then visited Trevor Weiss, and said, hey, man, if anybody asked, make sure you're telling them that we were playing video games together, right? Remember, this is the same defendant who wanted to tell somebody what happened. Before all this happens, we heard from Megan, her efforts to try to find Melody, found her phone, how she found the phone, that she realized that there was information that could provide her with details about where she had been that had been deleted from the phone. And then we heard, unfortunately, because of the damage of the phone, we weren't able to get anything other than what we initially could see. Although that was quite enough information. Then we saw on February 18th at 9:30 a.m., Amy Robas arrived at Lily Pond and found Melody. Made a 911 call at 10:12. At 10:15, they called back. And then minutes later, Deputy Teed arrives on the scene, and he finds Melody absent the medical intervention devices in this condition. She was declared deceased at 10:37 a.m. Meanwhile, we see some more activity here. Megan makes a missing persons report at 12 p.m. on February 18th. Defendant visits the Iowa Missing Persons alert. Apparently his way of getting help. And then Detective Peterson sends an ATL out on the defendant's vehicle at 7:20 p.m. There's some more searches for Megan Hoffman. And then at 8:23 p.m., the defendant views a Snapchat photo of Dakota Van Patten wearing Melody's glasses. At 9:39 p.m., defendant visits Iowa Missing Persons alert again. He then views a video from Dakota Van Patten Snapchat of him wearing glasses. That's within that phone tag report that was received into evidence. He searches Megan Hoffman on Facebook a few more times until about 11:26 p.m. And then at about 2 a.m. on February 19th, we hear that the Cedar Rapids Police Department locates the defendant's vehicle. Initial observations are there's no blood observed inside the passenger compartment of the vehicle, which is a notable finding, and no blood was observed either by the crime scene investigators, even though we heard about all the things that took place in the back seat. No tissues or clothes. Search warrant was executed, and this is what they found, in my opening, I referred to as a kidnapper's bag. Well, duct tape, knife, clothes belonging to Megan Hoffman with duct tape on them, gloves, machete wrappers, her cell phone case, receipts, everything that gave the investigators immediate story about what happened to Megan Hoffman that they put together. Some more events that happened after that. Defendant searches Megan Hoffman's Facebook page first thing in the morning on the 19th. Does it again at 5:52. And then about 8 o'clock, he calls the Marion Police Department about his car. At 10 a.m., he talks to Kelly. Multiple opportunities to talk to the police here. Calls back. Searches for Megan Hoffman on Facebook. Visits her. And then at 4:21 p.m., he arrived at the Marion Police Department. And at that point in time, investigators knew that they had this bag full of Melody's clothes, duct tape, knife, the paracord, a knife with blood on it, the machete, all those sort of things. But they give the defendant an opportunity to free narrative. Tell us what happened. And during that first interview, the defendant provided to investigators essentially a completely fabricated story. There were some initial things that were later supported by the evidence, but generally it involved somebody having his car for 45 minutes. And I was just playing video games with Trevor, and Melody died? Oh, really? Because, she was purchasing me a phone, and she and my girlfriend don't get along, and just the things he said during that interview. Then they had a second interview. And during that second interview, he said there were some things I left out. And then proceeded to tell the tale of his friend Dakota Van Patten, who the evidence shows didn't even know Melody Hoffman. In front of him, at gunpoint for hours, forced him to do these evil deeds while he did nothing in return to help her. Talked about not having his phone available. Talked about being scared, wanting to tell somebody so bad, all the efforts that he took to try to get somebody's attention. But it took till 8 o'clock, having multiple opportunities to do so, for him to finally say what happened. Well, it didn't add up. The evidence doesn't support his theory. It doesn't support his story. Folks, Melody Hoffman was restrained, confined, subjected to unspeakable physical and mental suffering. She was removed from Morgan Creek Park to Marion and then to Lily Pond, where she was strangled, stabbed, slashed, mutilated, stripped, and left face down on the ground. Dead at the hands of the defendant and Dakota Van Patten. And there's no other explanation that makes sense. As we told you we do, return to you at the end of this case. We laid out for you the best we could, minute by minute, sometimes second by second, what happened. We have shown to you, ladies and gentlemen, that the evidence in this case supports that the defendant and Dakota Van Patten were the primary perpetrators and the aiders and abettors of each other in perpetrating this horrific offense and offenses. Any doubt that has been raised, any doubt you might hear, is not reasonable. Therefore, there's no reasonable doubt. I may return to you to add a couple more things here in a minute, or a few. I want to be clear. The state is asking you folks to evaluate this evidence, take a look at it all, do your own breakdown, do what you need to do. But we submit to you that at the end of that evaluation, you will find the state has proven beyond any doubt that is reasonable the defendant's guilty of murder in the first degree, kidnapping in the first degree, and conspiracy to commit a forcible felony. Thank you.
Thank you, Mr. Maybanks. We're going to take a recess here. Jurors, it's going to be 15 minutes. We are going to work into lunch, so I know there's some snacks in the jury room. I encourage you to have a snack. Lunch will wait for you. When we come back, the defense will have their closing argument and then a rebuttal from the state. And so have a good morning recess. We'll see you back here in about 15 minutes. Until the case is submitted to you, you still have that admonition, so you're not allowed to talk about the case until it's finally submitted to you. So you're still under that admonition, and we'll see you back here in about 15 minutes. right, we are back on the record in FECR 153477. At this time, the defense will give its closing argument. Mr. Moore?
May it please the court, counsel, Mr. Louisma. Ladies and gentlemen of the jury, we appreciate your patience and attention over this long trial. Now it's time for the defense to make its case. Let's start by going back to January of this year and discussing where things stood in the relationships between the relevant parties to this case. January of 2024. Excuse me, we got clicked ahead one. Let's talk about the parties generally and what we know about them first. We know that Nakia and Ken were in an on-again, off-again relationship for several years, and they eventually broke up on July 4, 2023. Melody Hoffman and McKinley Louisma, Ken, then met in October 2023 and began dating. Nakia and Ken then reunited again sometime in December of that same year, 2023. And Melody and Ken broke up sometime around or before January 7 of 2024. These facts have been well established. We know that Ken retrieved his property from Megan Hoffman on January 7, 2024. And then on January 26 of this year, 2024, Melody, Ken, and Nakia, all three of them were involved in some kind of chat on Facebook Messenger. The conversation was between Melody's account and Ken's account, and we know that Nakia was party to that conversation as well. This is what we know about the three individuals. In January of 2024, this year, Ken and Melody had split up sometime in January. And at some point in January, both of them had expressed to the other that they were over it. It was done. They were through. They both said that at different points during this month. We also know that Nakia Svoboda was pregnant at this time. Her child was born on April 8th of this year. Now, January 7th is a significant date. First off, on January 7th, or on the night of January 6th, just prior to January 7th, Melody sent messages to Mr. Louisma from some kind of dummy account or fake account with a different name, under the name Maddie Brown. We've seen those messages. They talked about things that night. She said she posed as Maddie Brown for a period of time, and then eventually the gig was kind of up. Ken said, "I know it's you," and she said, "I'm going to throw your stuff away." What we had in that conversation is typical young people in a relationship behavior. Breakups are hard. We have testimony that this was Melody Hoffman's first long-term relationship of any kind. You had a little love triangle going. And in those kinds of situations, people can get hurt. The conversations there were all normal. Young people in relationships show their feelings. But Melody was kind of messing with Ken at that point, talking from a fake account, talking to him as if she's somebody else. This is on January 7th. Then later in the day on January 7th, we know that there was a property exchange, that Ken got his property from Megan Hoffman, that Melody was not there for that. Megan Hoffman described that process as peaceful and said there was no incident at the house on that day. And then later on January 7th, Melody Hoffman received some threatening texts. Please keep in mind, there was an investigation by police. The case was closed. You should not be firmly convinced that McKinley Louisma sent those messages today. No charges were ever filed on him, in part because there would not be reasonable doubt that a jury in a case hearing, if a charge was brought, a jury in a case hearing that McKinley Louisma was charged with sending those threatening texts, that you would not be firmly convinced in that trial that he sent those texts. And you should not be firmly convinced of that today. The source was never ID'd, and the case was closed. Fast forward a couple weeks to January 26th, we have the three-way Facebook Messenger conversation. Melody expresses, "Tell him I'm done with his goofy ass. Have fun with Kia because I'm done with your bullshit." She's expressing to Ken that she's finished with the relationship, and he expresses the same in that conversation. Both parties are saying they're done with each other. The love triangle has broken to some degree. And Melody and Ken both said they were finished. Now, the period after January 26, leading into the important dates of February 17 and 18, it's a little unclear as to what happened there. Ken and Melody had some level of communication. We know that much. Megan Hoffman said that at least one time after the breakup, Ken had come to their residence and that she monitored that interaction. She supervised that event using her camera in her house. But it's really not clear anything of what happened. We're not sure exactly what time, what day that visit to the Hoffman residence for Mr. Louisma came, and we're not sure how much conversation took place between the two of them following the breakup. This is a picture of the Facebook Messenger exchange. The parts highlighted in blue are from Maddie Brown, where Melody is pretending to be someone else, presumably Maddie Brown. And then the pink-colored one, "We're going to throw away your stuff," where she makes it clear that this is Melody speaking. Let's fast forward to February 17, 2024. Ken was living in Hiawatha with Nakia. It says at her grandmother's house. I think she referred to her as her Nana, but she may not have actually been a grandmother. Nakia said that she was in a relationship with Ken and things were good at that time. Melody had a conversation that's been documented by the state with someone else about wanting to be in a relationship, an Instagram handle by the name of King Leo Legend. And we know also on that day, February 17 in the evening, that Nakia needed medical attention and went to the hospital. Ken also went with her. That has been established. And again, these are the Instagram messages between Melody and King Leo Legend, who is not Mr. Louisma. Also, on or around February 17 and 18, you heard from two very important witnesses in this case, neither of whom are credible. You heard from Brandon Monson and Taya Meyer. Brandon Monson says Logan got in a car with him, got in a truck ride, and that he had a plan with two other people to commit a murder, and it was supposed to happen that night. Now, Brandon Monson came in and testified in this trial that what Logan said was that he had a plan with Dakota Van Patten and McKinley Louisma to commit a murder. But Brandon's story has changed over time. In the past, at his deposition, his recollection was refreshed with his deposition transcript, where he said he didn't say anything about being involved with anyone else specifically. That he just said he had a plan to commit a murder, but he didn't say who it was with. He had to be reminded from prior testimony. His story has changed twice over time. Brandon also admits to memory problems. So while you may walk out of here believing that Logan Kimpton got in his truck and said, "I have a plan to commit a murder with somebody," you should not be firmly convinced that what Logan Kimpton said that day was, "I have a plan with McKinley Louisma and Dakota Van Patten to commit a murder." Similarly, Taya Meyer, who is Brandon's girlfriend, also gave important statements. And we should point out, this truck ride where Logan Kimpton confesses to plotting a murder, Taya Meyer was right there in the back seat with Brandon. She didn't give any testimony about what Logan would have said. And again, Taya Meyer says that on the day after the incident, that Dakota came to her house and admitted, "I killed someone." And she said that he admitted to planning it with Logan and Ken. She has the exact same issue with her testimony, that in her deposition, her memory wasn't fresh with her deposition testimony. Asked if if Dakota had said who he committed this murder with. No, he didn't say anything like that. So you have a confession from Dakota Van Patten saying, I killed someone, and then alternating testimony from Taya as to whether or not he said he did it with someone else. She's inconsistent, and she's not credible. Both of these witnesses might be taken to say that people made confessions to them that they did something, but they cannot be relied upon to say that they did it with McKinley Louisma. Let's talk about Dakota Van Patten. We know a set of facts about Dakota Van Patten. First, we know that the paracord used to strangle Melody Hoffman matched a bundle of paracord from the basement of his residence. We know that Dakota Van Patten possessed a BB gun at 10:23 p.m. on February 17th. Sergeant Peterson testified to this, and you've seen the pictures. This is a photograph of the gun. Some BB guns, there's no denying this was a BB gun, but some BB guns, from your common knowledge, you would know, they're made to look like BB guns. They're made to look like fake guns. And other BB guns are made to look like real guns. And Sergeant Peterson, who claims to be a gun expert himself, testified. This looks like a real gun. This is not one of the guns that is made to look like a fake gun. And this is the image from 10:23 p.m. on the night of February 17th. We also know that on the night of February 17, Dakota Van Patten took a photo and kept it in his phone with Melody Hoffman's phone password on it. We know that Melody's phone connected to Dakota Van Patten's Wi-Fi hotspot twice in the early morning hours of February 18. We know Dakota Van Patten took Melody's glasses, kept those glasses in his basement, and took a selfie with the glasses on. Dakota Van Patten was not ashamed of what he had done. He flaunted it. He confessed his crime to someone else within hours of committing it. He took a selfie. Dakota Van Patten's DNA is found on the inside of glove 2, Melody Hoffman's glasses, and the used roll of duct tape. Again, he made that confession within hours of Melody's death. And finally, Dakota Van Patten is 6 feet 1 inches tall. Melody Hoffman was 5 feet 4 inches tall. McKinley Louisma is 5 feet 8 inches tall. And you heard from Dr. Cruz that the marks around Melody's neck indicated an upward pull of force. He was substantially taller than Mr. Louisma. Now let's talk about some of the locations that you've been given and shown on Mr. Louisma's phone. There were 2 different types. The first was from the cell phone towers. Now this is a capture of cell phone connections from midnight to 3 a.m. on the morning of February 18. I want you to pay attention to number 2 down in the left-hand corner. When you go back and look at the cell phone tower analysis, Sergeant Peterson from Marion Police Department entered it into evidence, Exhibit 17A. That number 2, that ping off cell phone tower, 3:04 a.m., is the only marking you'll see from Mr. Louisma's phone that puts him anywhere southwest of the Cedar Rapids Metro. That tower, that is not Walford. That's the southwest side of Cedar Rapids, pointing toward the southwest. That is the one ping that they have on these cell phone tower identifications. Melody's phone went down to Lily Pond. Dakota Van Patten's phone went down to Lily's Pond. This is the sole ping that you have for Mr. Louisma's phone, and it's inside the Cedar Rapids. I don't know if I could technically say that's within city limits, but it's close to Cedar Rapids or on the edge of it. Now let's look at the other source of data that you have for geolocations on Mr. Louisma's phone. This is from Exhibit 27. These are the slides of the phone pings, the geolocations. This is not connecting to a cell tower. This purports to be the actual location of the phone. This came in through Investigator Holst from Cedar Rapids Police Department. Now, I'm going to point out some of these to you, and I pointed out a few to him while he was on the stand. I pointed out some Walmart pings that they had on his phone that were narrowed down to an accuracy of 4 or 5 meters. Mr. Louisma was at Walmart on the southwest side of Cedar Rapids on the night of February 17th. You've seen the video. But there are varying differences in the accuracies of some of these phone pings. This is at 11:24 p.m. This is in Marion, 465 meters. Now, I asked Investigator Holst on the stand, do you agree there's about 1,600 meters in a mile? And that is about correct. It's 1,609. So 465 is more than a quarter of a mile. 465 meters is more than a quarter of a mile. And we talked about this system creates a circle of accuracy. And we talked about radius and we talked about diameter. Diameter is twice the distance of the radius, the whole width of the circle. So this creates a circle that's over a half a mile in width. And they can narrow his accuracy of this phone's location within a half a mile of that circle. It's a pretty big area, but I think it still places you in Marion. I don't think it probably gets you outside of the Marion city limits at that distance. However, as we move on throughout the night, we find more varying degrees of accuracy. This one's taken on Collins Road Northeast, 1,400 meters. Now we're approaching almost a distance of a mile in the radius of that circle, and the diameter of that circle would now be closer to almost 2 miles. That's a pretty big circle. We're still probably close enough that we're inside the Cedar Rapids metro, but that's a mile, nearly a mile in any direction on the accuracy. This is the one ping that the state gave you on the defendant's phone from Lily Pond. And I want you to pay attention to the accuracy. 6,256 meters. That is nearly 4 miles. That creates a diameter of the circle of over 7.5 miles. That's a big circle. And this is the one ping on Mr. Louisma's phone to place him at Lily Pond. Nearly 7 miles wide. Not all of this data is entirely accurate. We have a couple more. We have one that's 11:59. That's about 3/4 of a mile. That's down south of Walford. So that would create a circle with a diameter of 1.5 miles, the total circle. And we have a second one near Walford that's 2452, 2,452 meters. That's about 1.5 miles. So you've got a 3-mile wide diameter on that circle with the measure of accuracy. So again, the Walmart pings are accurate down to 4 or 5 meters. The pings southwest of Cedar Rapids are not. And keep this in mind as you look at Exhibit 21. The state has tried to cross-reference multiple forms of data to give you an idea of who is doing what at what time, right down to who is taking a certain number of steps when they were in a certain location. So the data at 12:09, 12:34, that's talking about the device being at the south side of Morgan Creek Park. The health app indicated 2 sets of steps during that time. First set was counted at 28 steps. Second set was counted at 29 steps. Okay, that's fine. We can establish that at Morgan Creek Park. We cannot establish nearly as accurate of data from Lily Pond, given what the state has shown you here. And it shows in this report. Pay attention to what words you see in this report. Device travel southwest near Highway 151 in Walford. Device in the area of Lily Pond. Now at 2:15 a.m. they say they've got him locating the green space at the pond. But remember, you just saw that circle. It's over 7 miles wide. So I don't know that you can really be firmly convinced of any specific location within Lily Pond. And this blue part there at the bottom, the health app indicating the number of steps, it's just not homed in enough to be accurate, for you to be firmly convinced that these events took place in this location at this time. So, we've talked about Mr. Louisma's interview in this trial. What parts of that interview are corroborated? First, that he went to the hospital to be with Nikia Svoboda. Second, that he gave Trevor Weiss a ride home after work on the night of February 17. Third, that Dakota Van Patten had a gun. And fourth, while driving in Walford, Mr. Louisma went to the BP gas station, drove slowly so as to appear conspicuous. While driving, he took a route close to the Hoffman residence in Marion. And when they went to the Quick Star, the state will tell you that Mr. Louisma led him in. But Mr. Van Patten, and that's true, Mr. Louisma did walk in first. But if someone was holding you at gunpoint, they would walk behind you. And Mr. Van Patten walked behind Mr. Louisma as if holding him at gunpoint. And most importantly, there's no DNA and no fingerprints of McKinley Louisma on any evidence. Now, Melody Hoffman's pregnancy is only important because the state wants to make you believe that that is a motive for Mr. Louisma to murder her. We should remind ourselves, Megan Hoffman said that she and Melody were best friends and that Melody kept very open communication with her. And Melody had not told Megan that she was pregnant. And we've talked about the HCG level. Melody's HCG level at the time of her death was 7.3. It was either going up for a new pregnancy or coming down from some kind of miscarried pregnancy. And we really don't know which one it was. But we do know that 7.3 is not even high enough to trigger a positive on a home pregnancy test, even the most sensitive ones out there. No paternity has been established on this child. No knowledge of this pregnancy by any person relative to this trial has been established. Not even Melody's knowledge. We don't know if anyone knew about her pregnancy. And you should not be firmly convinced that anyone knew. That's the accurate way of stating it. You should not believe that anyone knew about this. And certainly there's no evidence that McKinley Louisma knew of this pregnancy. In opening and throughout this case, the state has made a few promises to you. Some of those have been unkept. They told you in opening that Melody was pregnant with McKinley Louisma's child. Unproven. She might have been pregnant. She might have been previously pregnant. Nobody's proven that she was pregnant with McKinley Louisma's child. Again, that Melody's pregnancy was a motive for McKinley Louisma to commit this crime. In opening, the state said Melody's secret had reached a boiling point. It hadn't reached any point. Nobody knew a thing about it. There's no evidence that anyone knew anything about it. They told you in opening they would be able to tell you where Melody Hoffman's death took place. They've attempted to tell you that today. I would submit that they were suggesting in opening that it took place at Morgan Creek Park, and now today they're suggesting it took place at Lily Pond. Finally, they told you that McKinley Louisma, in opening, they told you that he had intimate knowledge of Lily Pond. You heard one witness tell you that he'd been there one time. Nikia Svoboda said he took her there one time. That's not intimate knowledge. So now the case is drawn to the close. It's time to perform your ultimate role as jurors. You heard a lot about reasonable doubt and voir dire, and you have jury instructions about what reasonable doubt is. But now is the time to check your level of certainty. What are you firmly convinced of? And that's not being firmly convinced of each charge. That's being firmly convinced of each element of each charge. I like to compare the elements to a bucket. That you have a bucket for each separate element of the offense. And that bucket needs to be filled to a line. That line's called reasonable doubt. That you're firmly convinced. Where do you draw the line on that bucket? That's for you to decide. You decide the facts in this case. What are you firmly convinced of? Each individual element to return a conviction. And once you do that, you'll return 3 verdicts of not guilty. Thank you. Thank you.
Thank you, Mr. Moore. At this time, the state will have an opportunity to provide a rebuttal argument.
Sorry, folks, I had to get mic'd up one more time. I promise you that within minutes here, you will have this case finally to talk about. But please indulge me as I take just a few moments here to respond to some of the arguments the defense made in this case and some of the statements that were given to you moments ago. I don't usually do it, but I'm going to start out a rebuttal by agreeing with something the defense said. In a love triangle, people get hurt. And I think that cuts right to the heart of this case and right to the reason that you all are here today. In their closing argument, the defense didn't come out and say it, but they want you to believe that Dakota Van Patten is solely responsible for Melody Hoffman's death. They want you to believe that this was Dakota Van Patten, that he's the one that's guilty of this offense. Again, we agree. But so is he. You heard that typical people act this way in relationships, have these fights. But typical people do not do what the defendant and Dakota Van Patten did. Folks, there are a few things the defense said during their rebuttal that stuck out to me. That Dakota Van Patten was the one who had the paracord in his basement. But ladies and gentlemen, that paracord ended up in the trunk of the defendant's vehicle, tied to a towing rope. The defendant would have had to have had knowledge that Dakota Van Patten had a rope because the evidence suggests that the two of them decided to bring that rope together. The defense brought up once again this menacing and threatening BB gun that looks like a toy. But ladies and gentlemen, we saw that around 10:23 p.m. on February 17th, right after they left Walmart, Dakota Van Patten openly took a picture of himself laughing with his BB gun while in the car with Mr. Louisma. The fact that Mr. Louisma would later say that he didn't know that Dakota Van Patten had a gun and that this surprised him does not pass any kind of credibility test. He clearly knew by the evidence that before they even got out, well, when they were still talking about going camping, apparently, that there was a BB gun. They brought up the passcode again, But we just showed you during our closing argument that that passcode was recorded in Dakota Van Patten's phone at 11:59 p.m. while they were still driving in between Cherry Hill Park and Morgan Creek Park, certainly before any events happened that involved physical assault or kidnapping or murder, which is directly in contrast to what the defendant ultimately described as the order of events in his interview. Dakota Van Patten kept Melody Hoffman's glasses. And I don't want for a minute for you to think that when I make the arguments that the defendant is responsible for this, that we're forgiving anything that Dakota Van Patten did. That is despicable. It's disgusting what he did. But it also proves, I submit to you, he's not a very smart person to do what he did to leave those glasses there. He's not the type of smart person that can pull off this sinister 4-hour kidnapping and murder, which the defense brought up again. The criminal mastermind admitted to the first person he saw after trying to hide the evidence and threatening Mr. Louisma with his life. It doesn't pass the credibility test. And yes, we do have evidence in this case that the DNA was on the gloves. That Mr. Van Patten's DNA was on the gloves. And that makes sense, because we heard the defendant talk about the use of gloves. We actually heard the defendant say something interesting in his interview where he said that when Dakota Van Patten got out of the car, that Dakota Van Patten ordered the defendant to put on gloves. We submit to you, ladies and gentlemen, when you review what the defendant said happened in this case, the evidence shows that the defendant was displacing who was telling who how to do things. We submit to you that's the case. But in any event, it definitely shows that the two of them were working together. So yes, Dakota Van Patten's DNA was on the gloves. Let's talk about the DNA again, because I knew the defense would bring that up. And I did discuss that in the original closing argument. When the defense talks about there's no DNA of Mr. Louisma on anything, remember, one of the first things he said, even in his first interview, when he realized that Special Agent Kedley wasn't believing him, that it wasn't adding up, he said, "Is that because it touched everything? How do you argue that your DNA is not everything, but you also said you touched everything?" Science isn't perfect. We're not always going to get the DNA profile we need. But the evidence in this case shows that he touched everything because he said he did. In fact, he was using that as a way to try to explain himself out of these circumstances. These exhibits that the defense just showed in their closing argument, that they were arguing that you can't believe them because they're not precise enough. And we're trying to figure out then, how is it by pointing out that he was within 1/4 mile of Melody's house at 11:24 a.m. means that you need to throw out all the exhibits of the cell phone information, because we know he was at Melody's house at 11:24 a.m. because that's when she left the house and got in his car. What was even the point of that? And then showing that the evidence we had at Lily Pond, where, the rural cell phone towers, they have a little bit different accuracy than some of the urban ones. That I think that was what Investigator Hall said. What was the point of that? Are they arguing now that he wasn't even at Lily Pond? And this jumping over the health data? You know how we know he's at Lily Pond? Because we know what he didn't know. His phone recorded him there, walking down, leaving his car, a place he was familiar with, a place he brought his girlfriend to for the first date, a place he used to work at. Remember that conversation he talked about in the interview? He said he was describing how they ended up at Lily Pond, and he didn't realize where they were driving. And Dakota said, "Let's go out to that pond out there." And he casually says, "Oh yeah, I used to work there." Like just having this casual conversation with Melody Hoffman in the back, all tied up. He knew Lily Pond intimately. And, like I said, what he didn't know is his phone was recording everything for you to look at later. Now, the defense didn't talk much else about the phone, and there's a reason for that. And they talked a little bit about the interview, and I want to get to some of those things here in a moment about the interview, because clearly they want you to rely on some of the things that he said. But even though we're getting into fall here, the defense isn't afraid of picking some cherries out of that interview here. They really focus on the things they wanted you to know. But you know what they didn't bring up? At multiple times within that interview, the defendant said that his phone was stuck between the seats. So now are we going to presume that his phone got up on its own and walked down there and watched Dakota Van Patten kill Melody? He didn't have an explanation for that. The defense didn't have an explanation for that. So they just cherry-picked their way around it. Cherry-picked their way around all this evidence in this case. The phone data we submit to you can be trustworthy. The defense argues that you can't believe that Melody Hoffman was, well, maybe that you can believe she was pregnant at some point in time, but you can't believe that she didn't tell Megan Hoffman about it. As if we can't surmise any kind of situation where a 20-year-old woman who's pregnant with her ex-boyfriend's child maybe doesn't want to run and tell mom that right away. Possible that could happen. Now, granted, we can't show you a conversation that took place between Melody Hoffman and the defendant about her being or late for her period, whatever it may be. But the circumstances around this show that there was a boiling point. And we have biological evidence to show that she was pregnant at the time. That's called circumstantial evidence, and you can give that the same way you give direct testimony and direct evidence. It just makes sense. Brandon Monson and Taya Meyer. They were only here in court for a couple of minutes. Just a few minutes, kind of one of our shorter witnesses. Did they look like they wanted to be here? No, they didn't want to be here. They would want to be miles away from this case. But they came in here, and they talked about things that they would only have knowledge of if somebody told them about it, we submit to you. And they have no reason to fabricate. We submit that to you as well. They were asked under oath what happened in that car. Brandon Monson said Logan Kempton was talking about a plan that he and Ken and Dakota had to kill somebody. We asked Taya Meyer under oath what happened. Dakota Van Patten said, I killed someone. And then she said, who? And he said, Melody. And she said, why? And he said, it had to be done. What are you talking about? Ken and I killed somebody. Under oath, you heard that. Can't rewrite that because you heard that with your own ears. Folks, there's so many paths we can go down when it comes to talking about what the defense wants you to believe in this case. And clearly what they're asking you to do is watch those interviews. We submit to you that when you watch those interviews, that 3 words are going to come to your mind. Unbelievable, unreasonable, and unsupported. And those are the 3 words I told you at the beginning of my closing argument. They're not supported by the evidence. What he said about his phone, not supported by the evidence. What he said about how the passcode got into Dakota's phone, not supported by the evidence. Too many gaps. I could take some more time and go over them with you, but I trust you folks. Just an example. No explanation in that interview of how Dakota Van Patten knew there was a kidnapper's bag available for him. Well, you know what a reasonable explanation for that is? They planned it together. Ladies and gentlemen, I want to leave you with the looming question that I brought up a couple of times, and the question you no doubt will have when you go back into the jury room, and that is the why. We've laid out to you in detail how this crime was committed. We've proven our checklists. That's all we have to do. But you're still going to want to know why. Because that's human nature. That's what we want. We want to answer those eternal questions, right? We want to understand why people do the things they do. And in a perplexing statement that the defendant gave in his interview, he talked about how he was supposedly in the back seat trying to cut Melody free while Dakota was driving in, pointing a gun at him too. And anyway, one of the things he said was Melody looked at him and said, "Why are you doing this to me? Why are you doing this, Bubby? Why are you doing this to me?" And it doesn't make sense that she would say that if he's trying to help her. But it does make sense that she would say that. Because like you folks want to know the why, so did she. But we submit to you, there's no good answer for that. Not today, not tomorrow, not weeks from now, not back then. There's no good answer for that because no good answer brings Melody Hoffman back to her family. That's why we don't have to prove why. But you know what we do have to prove? The checklist. What we talked about 2 weeks ago. And you'll get those instructions and you'll have that checklist. Folks, at the end of this case, after 2 weeks, presenting minute by minute, second by second, the actions of the defendant and Dakota Van Patten, showing what they did, giving you reasons to explain what they did, we've proven that checklist. And at the end of the defense cross-examination and closing argument, any doubt you have, we submit to you when you look at the evidence as a whole is unreasonable. That means no reasonable doubt. The checklist being proven, the defendant is guilty as charged. Thank you.
Thank you, counsel. At this time, the court will read the concluding jury instructions. Instruction 48. During the trial, you have been allowed to take notes. You may take these with you to the jury room to use in your deliberations. Remember, these are notes and not evidence. Generally, they reflect the recollection or impressions of the evidence as viewed by the person taking them and may be inaccurate or incomplete. Upon reaching a verdict, leave the notes in the jury room and they will be destroyed. Instruction number 49. When you begin your deliberations, you should select a foreperson. They shall see that your deliberations are carried on in an orderly manner, that the issues are fully and freely discussed, and that every juror is given an opportunity to express their views. In order to return a verdict, each juror must agree to it. Your verdict must be unanimous. It is your duty as jurors to consult with one another and reach an agreement, if you can do so, without compromising your individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with the other jurors. During your deliberations, do not hesitate to re-examine your view and change your opinion if convinced it is wrong. But do not change your opinion as to the weight or effect of the evidence just because it is the opinion of the other jurors or for the mere purpose of returning a verdict. Remember, you are judges of the facts. Your sole duty is to find the truth and do justice. Instruction number 50. You may not communicate about this case before reaching your verdict. This includes via cell phone and electronic media such as text messages, email, electronic messaging applications, and any social media platform, including but not limited to Facebook, LinkedIn, YouTube, Twitter/X, TikTok, Instagram, Snapchat, and any other social media applications you may use. Do not do any research or make any investigation about this case on your own. Do not visit or view any place discussed in this case. Do not use internet or application-based maps or programs or any other application, program, or device to search for or view any place discussed in the testimony. Also, do not research any information about this case, the law, or the people involved, including the parties, the witnesses, the lawyer, or the judge. This includes using the internet to research events or people referenced in the trial. This case will be tried on evidence presented in the courtroom. If you conduct independent research, you will be relying on matters not presented in court. The parties have a right to have this case decided on the evidence they know about and that has been introduced here in court. If you do some research or investigation or experiment that we do not know about, then your verdict may be influenced by inaccurate, incomplete, or misleading information that has not been tested by the trial process, including the oath to tell the truth and by cross-examination. All of the parties are entitled to a fair trial rendered by an impartial jury, and you must conduct yourself so as to maintain the integrity of the trial process. If you decide a case based on information not presented in court, you will have denied the parties a fair trial in accordance with the rules of the state, and you will have done an injustice. It is very important that you abide by these rules. Failure to follow these instructions may result in the case having to be retried and could result in you being held in contempt and punished. It is important that we have your full and undivided attention during this trial. Instruction number 51, I am giving you one form of verdict. When you have agreed upon your verdicts for each count and the foreperson has signed the verdict form, please notify the court attendant. Signed this 14th day, November 2024, Chad A. Kepros, Judge, 6th Judicial District. Be handing you one verdict form. Caption State of Iowa versus McKinley Louisma, form of verdict. Please place a check next to each of your verdicts. Count 1, check one option only. We, the jury, find the defendant guilty of murder in the first degree. We, the jury, find the defendant guilty of murder in the second degree. We, the jury, find the defendant guilty of involuntary manslaughter by recklessness. We, the jury, find the defendant guilty of involuntary manslaughter by conduct. We, the jury, find the defendant not guilty of count 1. Count 2, check one option only. We, the jury, find the defendant guilty of kidnapping in the first degree. We, the jury, find the defendant guilty of kidnapping in the third degree. We, the jury, find the defendant guilty of false imprisonment. We, the jury, find the defendant not guilty of count 2. Count 3, check one option only. We, the jury, find the defendant guilty of conspiracy to commit a forcible felony. We, the jury, find the defendant not guilty of count 3, and signature for a foreperson. And please recall, jurors, that there were those 3 typographical changes that were made. And so it will be the original instructions that I give you that you should each rely upon, and not the copies that you've been following with. And so you'll rely on this one set of original instructions. At this time, we will select the alternate juror. One of our 2 alternates was selected yesterday, and so we'll be selecting one alternate today. Remember that the alternate would be selected in open court, that no one knew who the alternate would be. And so what we have done is put each of your names on a separate piece of paper and a drum. I'm going to mix that drum up and pull one of your names out of the drum, and the name I pull will be the alternate. soon as I get Alyssa back, I have to swear her in, and then you'll have the case. Person to speak to or communicate with them, that you will not speak with or communicate with them except to ask whether they have agreed upon their verdict, that you will not reveal the state of their deliberations or the verdict they have agreed upon, that you will ensure that the exhibits delivered to the jury shall not be tampered with or left unattended, and that you will always conduct yourself in accordance with the court's instructions. Please answer, I do. All right, at this time, the case is yours, Schurz. Good luck. Thank you again for your service. You can all be seated. Jury has reached a verdict. Let's have the jury, please. You can all be seated. Juror number 4, I see you have some papers. Are you the foreperson?
Yes, I am.
Has the jury reached a verdict?
Yes, we have.
And is the verdict the unanimous verdict of all jurors?
Yes, it is.
I'm going to have you hand the verdict to the court attendant. I will now read the verdict of the jury. In the matter captioned State of Iowa versus McKinley Louisma, FECR 153477. Count 1, we, the jury, find the defendant guilty of murder in the first degree. Count 2, we, the jury, find the defendant guilty of kidnapping in the first degree. Count 3, we, the jury, find the defendant guilty of conspiracy to commit a forcible felony. Signed by the foreperson. Would the state like the jury polled?
Yes, Your Honor.
Jurors, I'm now going to poll you individually. I'll do that by juror number. And I'm going to start in the top left-hand corner of the jury box. I've just read the jury's verdict, and I'll ask each of you if this is your true and correct verdict. Juror number 1, is this your true and correct verdict? Juror number 2, is this your true and correct verdict? Juror number 3, is this your true and correct verdict? Juror number 4, is this your true and correct verdict?
Yes, it is.
Juror number 5, is this your true and correct verdict?
Yes.
Juror number 6, is this your true and correct verdict?
Yes.
Juror number 7, is this your true and correct verdict?
Yes.
Juror number 8, is this your true and correct verdict?
Yes.
Juror number 9, is this your true and correct verdict?
Yes.
Juror number 12, is this your true and correct verdict?
Yes.
Juror number 13, is this your true and correct verdict?
Yes.
Juror number 14, is this your true and correct verdict?
Yes.
Is there any record with regard to the polling of jurors from the state,
No, Your Honor.
from the defense?
No, Your Honor.
All right, jurors, I'm now going to release you with the thanks of the court for your service here during this trial. At this time, you'll return to the juror room, and then I'll be in to speak with you in just a few moments. Thank you very much. And then sentencing is set for December 6th at 1:30 p.m. Mr. Louisma, you have the right to file a motion to arrest of judgment and or a motion for new trial. If you choose to file either or both of these motions, you must do so no later than 45 days from today's date and no less than 5 days before the date set for sentencing. You can talk to your attorneys to learn more about these possible motions. Do you understand that right? Because the defendant has been found guilty of committing non-bailable offenses, the right to post any bond is revoked. Any final record from the state?
No, Your Honor.
From the defense?
Yes, Your Honor. I filed proposed exhibit defendants A, which I propose as a court exhibit. It is a 27-page PDF of Mr. Moore's closing argument that was published for the jury, with the exception of pages 26 and 27. They were not shown to the jury. I'd ask that the court accept that. I would ask that the state do the same with its closing argument PowerPoint.
What was the number again?
Letter, actually. It was defendant's exhibit A.
And that's just as a court exhibit?
Yes.
And is the state willing to do the same?
Your Honor, the state's PowerPoint did not just have pictures in it. There were videos embedded in it as well, so I don't know how we would do that. And given the fact that there were no objections made at the time, the PowerPoint was on the screen, then I don't see, I guess, a basis or a need for us to do that. But of course, we'll follow the court's guidance.
Is it contained in a single PowerPoint?
I would say it's, yes, a PowerPoint file, but I can't turn it into a PDF that would accurately represent the PowerPoint.
And I understand that concern. And from defense counsel, given that I didn't give that direction before, I don't know how they would load that in a form that I can preserve for the record, at least in EDMS. How would you suggest that be done, understanding the desire to have it?
I would request that it be put on a flash drive, and that flash drive be a court exhibit.
I mean, that's fine as long as it's understood that it would just be a PowerPoint. In other words, I'm not going to ask the state to produce it in a different form.
No, that's fine.
All right. I'm going to go ahead and do that. I have had direction from the appellate court that that be done if requested, simply so that there's a record of what was displayed to the jury. But I'm not going to ask the state to produce it in a different form than was actually utilized. And so if you would simply provide that on a separate flash drive with the PowerPoint and mark it as State's Exhibit 1, and it'll be received as a court exhibit. So it'll be court exhibit closing argument PowerPoint.
Would that confuse in any way with State's Exhibit Actual 1?
If you call.
Okay.
Any further record?
No, thank you.
All right, this record is closed. Thank you.